my lord, this representation may be considered by the my lord WPSCTCL in accordance with law.
Consider and dispose of.
So far, I dispute that there is a fault on the part of,
Dispose.
because they have already admitted.
His only grievance is non-consideration of representation.
But since no
Going
affidavit,
on merits.
let it be considered by the concerned zonal manager Medinipur or his authorized
My-
officer.
my lord.
The petitioner is aggrieved.
My lord, I am for the petition.
Yes.
All for the CES.
I do not know whether the private respondent is appearing. Unfortunately, my lord, the affidavit of service is yet to be found, but I have the photocopy which shows that, my lord, he has received.
He had feared it would have been happier.
Yes, I would have been.
Grievance.
Well, a very short prayer. It is for shifting. My lord, they also admit the meter can be only shifted if an order is passed by the court. Now, my lord, what are the facts before your lordship? My lord, it's a property which was initially owned by my grandmother. Now, my lord, my grandmother, prior to her death, my lord, gifted a portion of property to my maternal uncle and a portion to me. I'll show from the deed that admitted position that my uncle is having the first floor and I will be having the ground floor. Now, my lord, a meter has been put in that place, which my lord, is done with a purpose so that my uncle can take possession of the ground floor as well. Sorry, my only simple prayer is that I'll show from the records also, my lord, the meter may be shifted anywhere within the premise to outside the premise. Nothing more, nothing less.
Firstly, my lord, this was already a shifting had taken place. This application is since 2023, this dispute is going on. It is an internal feud, dispute and a civil dispute, my lord. Now, my lord, the current position is we have held an inspection and the service has been found in one room which both claim to be a common room. But that has been there. So if there is a shifting, if that is possible, then the registered consumer, which is perhaps her uncle.
No, that is the fallacy.
So they
That is the fallacy.
identify a common position.
I am the registered consumer because I will show from the deed.
It stands in your name.
Kindly seize the deed, my lord. Kindly seize the deed. Please
Registered-
let me finish, ma'am.
Registered consumer
The
would be
registered consumer was my grandmother.
complete.
Was my grandmother.
Registered consumer would mean the name of the person in whose name electricity connection stands.
Stands.
Yes.
Now, my lord, kindly appreciates if your lordship has a connection in your own name in my portion of the premises, whether I would be entitled to shift it or not. That's the question before your lordship. Because I'll admittedly show from the deed, my lord, kindly takes up page 13 and 14.
Then their presence is important. You cannot have it in there.
Yes, my lord, services, yes, service. I'm grateful. Kindly have a look at
No, service is not complete.
in respect of the private respondent. Yes, my lord, I find it.
Then
It's kept on hold.
My lord, the consumer is the uncle.
affidavit of service filed in court today is taken on record. Service on the respondent number
It's a private respondent, my lord. Only
for the petitioner.
I don't know.
The strangest of an application, they invoke in Electricity Act when there is a surface pending against the landlord. And there is an eviction, there is a suit not to evict.
Yes, there is a suit pending by which they have get injunction order, Lordship.
None appears for the petitioner. No accommodation is prayed for. The respondent
Your Lordship, on behalf for short passover, as a senior counsel is not yet here. Mr. Najat Chaudhary,
after
much obliged, Your Lordship.
Taken up, my lord, after 12.
yes.
My lord, I am for the petitioner, my lord, but the difficulty is that, my lord, the learned advocate on record has not completed the service, my lord. My lord, kindly adjourn it for a week, my lord.
Likhenin. It is submitted by the learned advocate appearing for the petitioner that service
Seven column.
Seven lordship. Which? So I am for the, Lord, I am for the item 4 only, Lord.
4 has gone, whatever is there, yes.
Alert.
Item 7 is going on.
Item number 7, I am for the petitioner. This is pursuant to a construction of a project where electric connection was applied for. But there is no reason specified for delay. The for installation of the transformer and electric connection, Miller, in the said residential project. A development work was initiated. A building was duly constructed and
Want installation of transformer.
yes,
They are not doing that.
they have not.
Yes,
We have paid the amount.
My lord, this is Jila Parishad has written a letter to us that is unauthorized construction is there. The building most of the part unauthorized construction number 1. And 14 in paragraph 14 also they have admitted the neighbors, they have claimed they have filed title suit and also my lord, they are saying they are opposing, but they are not made party. So these are the two basic my lord, problem we are facing on over my lord phone. This is the instruction to me. In paragraph 14 they have admitted that some objectors are there and title
File a
suit.
report why you are not installing the transformer. The petitioner is aggrieved by the
mentioning, my lord, regarding item number 1, my lord.
Appear tomorrow as.
Well, I was trying to join over online, but I was not being allowed.
Well, I have called it. This is not how you mention.
Milord, item number 4, Milord, due to very raining, I could not. Item number 4, Milord.
Why are you mentioning now? The list is being called to mention like this in the middle. Not today, not today. Yes.
Colin. I am for the petitioner, Lordship. Lordship, this submersible pump connection, Lordship. Petitioner has applied in the year 2023.
But we have made an inspection. What is my instruction is that, my lord,
Nothing has been done. Meter room, pump.
let him
Same one.
There is an order, you show it to him. I'll pass this order. এই এখানে মিস্টার শুক্লার জায়গায় withdraw. Nine. Yes. That matters.
May I start?
Yes.
No written instruction on behalf of the bank and not yet. And what I have been conveyed verbally, that this proposal is not going to be accepted. They will not reject it. And I have also brought a judgment which I will rely on. I have raised my point on the last occasion, day before yesterday, on maintainability. I placed this judgment before your lordship.
Maintainability.
Yes.
There.
Relevant paragraphs are there.
Are you relying upon?
Yes, I'm relying on
Mr.
G. Vikram Kumar versus
Over
State
there,
of
I
Hyderabad.
need to work out your remedies even with them if you can.
No, my lord, she has made it very clear. I mean, at least on the last date, an impression was given to me and also to the Honorable Court that the bank, she has instruction from the bank that they will accept if we agree to what they have proposed.
No, that was not. The word was they will reach a decision as to whether or not they will
accept or not.
But, my lord, may I only add this if my lord permits me to do so? My lord, may kindly take up that very letter, my lord, just once. In that case, my lord, kindly decide the writ petition on its own merit. Why? Because, my lord, why? Because
in any case, it's a surfacey measure. You please go before.
But, my lord, I must, may I draw my lord's attention to page 152 once. 152, which is the letter. My lord, in that case, if they are withdrawing, I am withdrawing my concession also because I have conceded to the court. Otherwise, I was not.
It's not working. It's not working.
It's not working. The merits will play its role. My lord, may kindly consider page 152.
Yes.
What does the bank say?
Yes.
After, my lord, the contract whereby I was called upon to pay a particular sum of 5 crore 12 lakhs, I paid 5 crore 68 lakhs. Now, my lord, after that, this mail has come. Total compounded interest to be, my lord, deviation, 1 crore 81 lakhs and odd. As per instruction, my lord, kindly see higher authorities. Kindly deposit the compound so that the proposal for condonation relief may be forwarded to competent authority for approval. Now, it has been declined. And now, my lord, here, there is no time again mentioned. So today, in open court, if I make a suggestion that I am ready and willing to concede to their claim, my lord, this is absolutely arbitrary.
That again, I will not have jurisdiction. You are well aware of judgments because this is something which is going into the realm of settlement and compromise. I cannot force.
My lord, this is possibly not settlement.
Yes,
Why, my lord? Why, my lord?
Because
it's a concluded contract and acted upon.
It does not appear to be so, at least prima facie, because page 152, they say that this amount, if you pay, we'll forward your proposal for condonation of delay. That is, there is delay in
Yes.
something. Now, to that you bargain saying that no, not 1.8, let me give you 1. Now, these things are stalemate at this. You come up with a writ petition now after a scenario, after in this scenario, they come up with a sale notice. Then you come up in writ petition saying that this sale notice is arbitrary.
May I, my lord, make
There
this
is-
submission? I have understood, my lord. What has fallen from the honorable bench, I have been able to gather, my lord. Kindly consider that this offer of one compounded interest, 181, to which I have made a counter offer of 1 crore, did not culminate into a contract.
Very well, it has not culminated,
But, my
then
lord,
it shows that you are also not treating the earlier delayed payments as a payment in full and final settlement. If you had, then in that case, that is why I say, Mr. Mishra, but because these observations are again going to be observations on merits, which I don't want to do. Please go before the DRT. I'll leave all of this open, that parties have not been able to reach a settlement even at this.
and my lord, I am at a threshold where my auction, and they are more vindictive. They have again gone to yesterday to my property, and they have.
On second, that is why I'll send you today. Tomorrow you file the application. I'll give DRT direction that it will hear it tomorrow itself, because your auction is on second.
On second.
You still have 1 day tomorrow and a Monday, and again another day, because second you have 3 working days before second. That should suffice for you to, at least, if you have a prima facie case, you can get an order. If you don't have, you don't have. If you have, why don't you? But why should we jump that forum?
My lord, I was not. I was only trying to beseech my lord only to an extent that if
I could have understood, Mr. Mishra, some kind of case being made out if this 151 had not caught my notice. This
Not even 151, if my lord kindly reply.
151 gives an impression to the court that yes, parties are still at a stage of negotiation. Now, if they are at a stage of negotiation, a concluded contract in the sense that you want the court to accept is yet to come into existence. Now, if that is the case, surfacey remedy they have invoked at a time when there is no concluded contract, negotiations are on, you will be free to negotiate, you will be free to challenge the notice. I am not making any observation on merits. All of this, lock, stock, barrel, go before the DRT, have it done. In view of several judgments, especially the recent ones, saying that no, it's like a total bar now.
Yes.
My lord, bar in
total
fact, if my lord
And in
is
this
reading the
judgment,
bar,
which I have
my learned
realized,
is
yes,
relying
yes,
upon
take,
which
take,
one?
take this now. Paragraph 24 and 25.
My lord, after this, my lord, lot is happened. My lord, here, I would rather, my lord, make this submission that kindly consider there, insofar as the subsequent negotiation is concerned, where it had stopped at 1 crore from my side, is merely an offer. My lord, I'm only for the risk of repetition.
Mr. Mishra, I would once again say what you are challenging here. You are challenging here the sale notice, the notice by which your property has been put up for sale. That has been done under the SURFACE Act. Now, it is nobody's case as at present that the bank is absolutely without jurisdiction in taking recourse to measures of the measures under the SURFACE Act, because you, as of now, you don't have a no dues certificate issued in your name.
I'm sorry, ma'am.
You don't have
No,
a no dues
I don't have.
certificate.
That is essentially my prayer.
Yes, no dues certificate issued in your name. You say you allege arbitrariness on the part of the bank in not acceding to appropriating the amounts paid by you in terms of your instructions, going by section 59 of the Contract Act. This is how you have to appropriate. Now, these are questions which would not knock the jurisdiction of the bank. The bank has jurisdiction to decide something wrongly. It has done. It has invoked SURFACE jurisdiction wrongly. But it is not that it has invoked SURFACE jurisdiction where it could not have invoked. For example, if it was one of those NBFC kinds where there was a threshold limit and they have invoked.
Or in case of otherwise, my lord, exception of fraud, misrepresentation, so and so forth.
Yes, or maybe a land which is governed by the Land Reforms Act and no valid mortgage can be created, and where SURFACE interest, yes, there is an inherent lack of jurisdiction. Some kind of a case may be made out. But then here it is not that case. Why do we waste time here?
My lord, I will possibly, my lord, I will not consume much more of a time. My lord, insofar as the facts are concerned, I have respectfully placed, my lord. Kindly consider the relief which I have sought for, because that will possibly
I
bring.
understand, because the relief which you seek is indirectly aimed at stalling the sale notice. I would have understood if prior to this SURFACE action having been taken, you had come up saying that no, this is arbitrariness on the part of the bank. from May 2026 till August 2026, there was complete silence. What made you break the silence was the issuance of the surface.
No, my lord, the silence which broke was the deliberation which was happening. My lord, kindly consider one thing.
That may be an explanation for the silence, good for the DRT to intervene, but not good enough for this court to ignore DRT's jurisdiction over this and assume jurisdiction when the Honorable Supreme Court has in very many judgments said, don't do.
My lord, I was seeing it in this with this lens, my lord. Kindly consider whether this, my lord, satisfies my lord or not. My lord, insofar as the contract is concerned, I have come to the writ court after the auction attempt is taken by the bank under surfacing. Simply, sitter, if this cause is the one, I would have gone to DRT and would not have ventured the writ jurisdiction. But my lord, my relief doesn't stop at that stage. My genesis of my right was their demand and their demand being duly paid. And my lord, when I'm saying so,
but there is no denial, but there was a delay. And
I paid interest on delay.
Yes, but now if they say that the interest which you are supposed to pay is not simple but compound, that is something which I as a writ court will not decide when surface action has been taken.
But if I say so, my lord, that this compound interest demand is an afterthought while the delayed interest as demanded was already paid, I was beseeching my lord to look into.
But Mr. Mishra, is this point not available to you before the DRT? This point is very.
No, my lord, this possibly is not available.
Why not? Why do you say it is not? Because the very root of their invoking surface jurisdiction is that something is due from you. That is the basis. That
I'm grateful, my lord.
Now, if you show before the DRT that nothing is due from you, definitely this is a point which is to be considered by the DRT. I can't see any reason for DRT not to consider this. This is definitely going to be considered because surface action could not have taken place in air. It has to have a basis. The basis is the dues,
secured debt,
which according to you is not there. So this is the basic point which the DRT will have to focus on, which I am also being invited to focus on.
Secured debt, if I am able to show to the honorable court
yes,
on the basis of the document.
This is where we are joining issues, that secured debt, whether it is existent or not, is to be shown to the DRT, not to me. To me, you could have shown that they are acting with total lack of jurisdiction. Now, this is not a case of total lack of jurisdiction.
Possibly, my lord, the Supreme Court, subject to correction, my lord, it is not only the inherent lack of jurisdiction,
it is total lack of
jurisdiction, which gives the honorable
wholly
court.
Without jurisdiction is the word in Whirlpool.
Yes, my lord, there are 3 stages on jurisdiction. I am aware of that.
Whirlpool says wholly without. It's fundamental violation of fundamental rights, violation of principles of natural justice, ultra vires, and wholly without jurisdiction.
Yes.
These are the 4.
Starting from Whirlpool's case, and thereafter there are umpteen number of lately as
without jurisdiction is not a case made out. Wholly without jurisdiction, and then as I said on the last day, ICICI Bank and Umakanto or something. Umakanto Mahaprabha.
Prabha Jain, Rumakant.
Umakant, one paragraph and punching paragraph saying that it's not maintainable, and still it's not maintainable is the word. Now, not even not entertainable. It's not maintainable is the word. I think it was Justice Nariman's. You can Google it and
yes, my lord.
It's just a one pager, and it's a punch that don't do it. It's not maintainable. It's in such a strong language.
My lord, the same court says that the honorable court's constitutional jurisdiction not maintainable is not the law of the land.
Right.
It is an inherent jurisdiction, whether will be exercised or not.
It is again question of
entertainability.
Godrej
Sarali, my lord, distinguishing Titagarh Industries judgment, my lord.
Entertainable and maintainable. It is always maintainable.
Distinguished.
Question is whether entertainable or not. Now, when here in the facts of this case, when I say that there is an equally efficacious remedy available to you, there is a dispute as regards debt due. There is a forum which is equipped with the wherewithal to go into this question. Why should I entertain this? Why should I entertain this? This question, in view of the settled line of precedents, does trouble me. And it would trouble you if you were in my place also. You are doing very well since you are presenting your party's case. I would have done the same thing if I was there. But You would have also done the same thing which I am doing if you were here.
Well, I was expecting my learned friend to come up with a positive, assertive statement,
Yes.
which,
On the-
alas, I could have had that.
On the last
opportunity, but
occasion, I tried.
nonetheless,
I will leave you free. It's
may I only make, my lord, I have only two options. Either I press my writ petition on its footing, on its merit, and it has its own fate as decided by my lord. Or in the alternative, my lord, as suggested by your lordship, my lord, I go to DRT and ventilate all my grievances. Either of the two,
And
which was not expected.
I'll pass a specific direction on the DRT
Expeditious.
expeditiously, since it has been filed on what date?
This was
filed on 20th of August.
20th of August.
20th of August it was filed. We are on 26th today.
My lord.
Tomorrow you go and file. You can, if you can file today, you file today. The day it is filed, you file a put up. Bank will be on notice. You give notice. Bank will not be asking for 48 hours or 24 hours notice, because bank has notice of your case now. And you go and plead your case before
My
the
lord,
DRT.
either of these two, I was expecting otherwise. My lord, please kindly take my lord's board. Item number 12, I'll also be addressing. My lord, in item number 12, a different matter, my lord. By that time, may I take instructions, my lord? Either.
Because merits.
My lord, I have understood, my lords.
Merits, I will be loath.
Very well.
No. With several judgments, I don't have the courage.
As your lordship pleases.
Yes.
Grateful.
দেখি পরেরটা কল করুন, পাস ওভার করে দিন। এটা সরি, এটা ওখানে রাখ।
In Lordship, I am for the petitioner. Lordship, in this matter, petitioner has installed two submersible pumps in Tatibiral Mauja, Lordship, in district Murshidabad, Sagordigi, Lordship, having two customer IDs. Petitioner is paying monthly bills regularly. Petitioner has complied with all the formalities and the connections are running. Now, Lordship, during installation of the said connection, WBSETCL authority has installed poles in order to energize the submersible pumps of the petitioners. Now, Lordship, the private respondent, respondent number 5, Lordship, also has submersible pumps in the state Mauja in different plot of land, Lordship. He also has applied for the connection for the submersible pump. Now, Lordship, the WBSETCL authority was trying to draw the wiring of the cable lines of the said connection over my plot of land. Petitioner objected. The private respondent filed one writ petition before this honorable court. Lordship, kindly sees the order, Lordship. Justice Kapoor passed one order by referring the matter to the concerned district magistrate. Thereafter, the matter was relegated before the district magistrate. In the said writ petition, I was not the party. I was never been made a party. Now, Lordship, in the hearings before the district magistrate, I was never given an opportunity of hearing, but I was the main person who has objected against the electricity connection of the private respondent. Now, Lordship, district magistrate has passed certain order. What has happened, Lordship, after the direction passed by the district magistrate, the WBSETCL authority has issued quotation for shifting of two poles, which were installed in order to giving connection to my submersible pumps. Lordship, the private respondent has complied with the payment has been made for shifting of the poles. Now, Lordship, if the shiftings took place, my connection of submersible pump will be damaged, Lordship. It will, because the poles will be shifted to a different plot of land and my pumps will be heavily damaged. There is a chance of burnout of the submersible pumps, Lordship. So I have also annexed the quotation. Lordship, the page 21.
Why is the shifting necessary?
Lordship,
Why is
that
the shifting necessary, Mr.
WBSETCL
Mukherjee?
First of all, my lord, he applied for the submersible pump. Connection has been given from two poles, but which is still there.
Yes.
Now, my lord, when the private respondent applied, we shifted two pole. We installed two pole. From that pole, we have not given any connection to anyone. Now, my lord, when we went to give the connection from that pole to private, my land friend's client, my lord, application, they raised objection. Now, my lord, we could not provide the connection. He moved before this court, this honorable court, the coordinate bench, my lord, directed the district magistrate to make an inquiry. And if it is found that the pole has been installed in his place, then we have to take steps in accordance with law. Now, thereafter, BLRO make an inquiry and found that the two poles has been installed in his premises. Now, my lord, there are four poles. From two poles, he is getting the connection, no problem. There are another two poles which we want to give connection to private respondent's application. Now, as per the direction of the district magistrate, now, my lord, we issued a quotation to him that we have to, my lord, remove those two poles and we have to install in your place. And for that, from that pole, you will get the connection. Now, my lord, he has paid the amount for, my lord, removal of that pole that we are doing. If we suppose today remove those poles, that will not at all affect him.
Mr. Haldar, how do you claim ownership of the poles?
No, Lordship,
You
not,
cannot be an owner
not
of the
the
pole.
poles, Lordship.
That is the property of the WBSCDCL authorities.
It-
They will install it or erect it wherever they feel fit. You have wanted it for your benefit on your land, you have got it.
Lordship.
But if you object to someone else getting
No,
it from the
I-
said pole itself,
No,
and
I
on
am
the
not-
second and on the same in the same breath you object to the other poles being shifted, then that shows
No, Lordship, I am
malafide.
not objecting him by in his getting connection. The
That is what his submission
WBSC
is.
also can install.
Otherwise, this entire exercise of going before the district magistrate would not have been required.
Lordship,
It was
may I
required only
submit?
because you objected.
Lordship, may I submit? The WBSCDCL authority can install poles in his plot of land, and by that they can give connection.
They may not also installed. Why should they bear the burden unnecessarily? There is a pole already there. If they feel that it is feasible, you don't have a right to get the pole erected at a particular place and not be
There is
taken
no
away from a particular
specific
place.
direction upon the WBSCDCL authority to shift
Not
the
required,
poles, Lordship.
not required.
And I was not
no
even
direction
given
is
an
required.
opportunity of
It
hearing,
is
Lordship.
for them to take a decision which will be the best possible route for the purpose of effecting electricity supply to a consumer or an intending consumer. They are well within their rights to take such decision. If you object to the installation of a pole on your ground, you may be within your right saying that no, this is my land, my property. Don't unnecessarily burden it by installation of pole. But if they are shifting a pole from someone else's land to some other place where you don't have any right, where is the question?
From my plot of land.
No, he says different.
No, from my plot of land, the district magistrate had passed the said order.
But there are total 4. Initially, when he applied, we installed 2.
Even if I take it is from your
But
plot.
may I just clarify, Your Lordship? I mean, now, my lord, initially when he applied, we installed 2 poles. From that pole, connection has been given to Mr. Haldar's client. Subsequently, my lord, when Mr. Ali applied, Mr. Ali's client applied. Now, my lord, what we have done, we had installed 2 poles, new 2 poles in the land of the Mr. Haldar's client. Therefore, in Mr. Haldar's client, there are 4 poles. There are 4 poles. 2 for the purpose of giving supply to him, his client, and 2 for Mr. Ali's client. Now, thereafter, my lord, when our contractor went to give the connection from that 2 pole, he raised objection. We could not provide the connection. Mr. Ali moved before this court. This honorable court sent back the matter.
So the poles which are going to be removed are from his property only.
His property only.
Not a problem.
Not a problem because
there is a regulation where
absolutely he cannot claim the ownership of.
yes, assets are not your property. They can remove it.
Well, shifting of pole, shifting of pole, total discretion of the WBSCDCL. If the service connection, the service connection of the petitioner
That is a specific regulation. This is the property of the WBSCDCL and they cannot. Sir, আপনার মামলাতেই তো order হয়েছে। And how he will be prejudiced because this is the pole of the WBSCDCL.
He is enjoying the electricity.
Regulation 13 of the West Bengal Electricity Regulatory Commission.
He knows it. And
No, Mr. Haldar.
Lordship, they are stating that there are 4 poles. Lordship,
Even if
give
it
me
is
1 day
pole
time.
for 5 pole, it will be within their domain.
Lordship,
we will not disturb his connector.
Lordship, kindly
record. We will not disturb his connector.
They are stating that there are 4 poles. Lordship, I will.
Even if it is 4 or even if it is 1.
Lordship, only
if
one.
They have to, if they have to shift it to a different place, you objected. You created this problem. Now you are in problem. You have come.
Lordship, kindly gives me 1 day time. I will only take instruction whether.
Regulation 13.
Yes, I have seen it.
Why 1 day
of assets?
He knows it.
Only to delay.
1 day time, Lordship, I will take instruction.
Not today.
So, kindly keep, because I will take the specific written instruction. Kindly keep it on next Tuesday, my lord.
Mr. Haldar, learned advocate, seeks an accommodation.
My lord, I'm for the petitioner, my lord. My lord, the petitioner availed a home loan, my lord, back in 2021, March 2021. Since then, they have been paying the EMIs regularly, my lord. My lord, in the meantime, the bank has invoked SARFAESI, my lord, and they have obtained the order by furnishing an affidavit, which is completely contrary to the.
Before DRT and
My lord,
challenge it.
the order was obtained on April 28th, my lord. So I'm barred by the limitation, my lord. That is,
Go and challenge all of this before the DRT. Listen.
my lord, they have, my lord, kindly sees, they have completely stating wrongly in the affidavit, my lord. I am paying.
All of this will be available before the DRT by High Court.
My lord, this is.
And in any case, it's a private bank. There is another hurdle.
My lord.
Your Lordship, my lord. So far as item number 9 is concerned.
9. Yes.
My lord will kindly keep all points open.
All points open.
The tribunal should not suggest that I will only look into 13.4 exercise and this.
Whatever is available before the tribunal, because whatever is available to you to argue in law will definitely, whatever is the route.
Very well.
Your argument is there is no secured debt.
There is no secret.
So that is your argument. I'll say that.
All points.
This writ petition
Your Lordship, my lord. Surfacey again. But my lord, equitable jurisdiction, clear instance of fraud. And my lord, fraud vitiates all solemn action. 2021, I bought the property. I invested, I started living there. I had no clue of what is happening between somebody with the bank. In 2026, I find that a notice has been pasted on my flat saying that there is a CGM order under sections 14 and a physical possession will be taken. My lord, I make a demand for justice. Inform the bank that I am the owner. Borrower is nowhere found here in the property in question. You kindly consider this, that the property cannot be claimed to be the secured asset. In view of the fact that the CGM order, which was also simultaneously affixed, clearly stated that there was some deed, some transaction in 2023, my lord, for 2 years after I had bought the property. Admittedly, matter of record. And my lord, on 10th of August, I was physically dispossessed. In other words, my lord, a person who has not obtained loan, is neither a borrower, guarantor, mortgager, pre-purchased the property, subsequent sale shown to have been mortgaged, loan obtained, and I am physically dispossessed without being heard. While I have made a demand for justice to the bank, they should have responded to it before taking coercive measure. They did not respond. And now, my lord,
the deed on which they are relying is subsequent to your deed.
Much subsequent. My lord, I am showing it. Kindly consider, my lord, my deed is at page number 53. Apparently, my lord, on the face of it, this is a fraud. Page 53, I bought the property. And incidentally, my lord, my vendor, 2021. Incidentally, my vendor is also the vendor of the borrower. And number two, there are 3 flats in 3rd floor sold to 3 different persons in 2021.
And where is their deed on the basis?
Their deed, my lord, will kindly consider at page 121.
Yes.
My lord, I have the mutation in my name. I'm paying property tax. I'm enjoying the property. Electricity bills are in my name.
If your deed is subsequent, then how can this
Milord,
surface
till
action?
now, Milord, from the bank, Milord, we haven't received any instruction, Milord. I've
When will you
received
get your instruction?
in the Milord a week's time, Milord.
They are out of their property on the basis of this deed. How could you dispose of
Milord,
them
the
then?
problem is, Milord, what they are saying over the phone, Milord, what instruction which I have got, they are why I need proper instruction on this, Milord, because even my learned friend's deed, Milord, and our deed does not possess any butted and bounded, Milord. The boundaries of the flat, it's not there. And there are more than, according to their petition itself, there are more than 1 flat in 1 floor, Milord. The floor which they are claiming. So the identification of that flat, Milord, it's still under dispute.
No, but if the property is the same,
Alone.
and you have purchased it in 2023,
2023, Milord.
and the same person from whom you have, who has mortgaged it to you, has sold it to him in 2021, you got nothing.
Milord, certainly, Milord, but there are, Milord, 3 flats on the same floor, Milord. For that, Milord, I require instruction, Milord, a week's time for that.
Let him come with the instructions.
For the urgency, kindly see page number 168.
They are already dispossessed, Milord.
I didn't know. I went to the bank that you have not replied to my demand justice and you have physically dispossessed me. They said I have put it on auction in bank's net. I traced the papers, I did not find. Kindly see, my lord, page 168, the next page 169. Today, 11:30 onwards, they will conduct an auction of my property.
What is your take on this?
Milord, I believe we do not have anyone, any purchaser or any bidder.
Come in, it's already 11:30.
Milord,
Auction has started. 1:30 auction will stop.
Milord, I'll take instruction, Milord.
Come back and tell me at 1:30 if there is bid or not, or I'll pass an order at least saying
Certainly,
that the sale will not be confirmed
Certainly,
till such time that is the only order which I can pass now.
My lord,
he'll come and tell us at 1:30 at 2.
Certainly, Milord. I'll take
that
instruction.
issue is still a issue which needs some deliberation.
We'll take a call on that, but till such time that the issue is decided, I'll not immediately annul the sale.
Well,
I'll say that he will not confirm it.
Milord,
until
apparently,
once,
Milord,
if
they are
bid
all-
comes at all. If
Milord.
there is no bid, then he will take instructions and argue.
Certainly.
Because he will have a 15-day breather anytime. If it doesn't, the sale doesn't,
Then
I mean,
Notify then, my lord,
Then
the
that
sale
is
clause
there.
is over.
yes.
But my lord, that is a micro point compared to the macro point on which
Yes.
they don't have a secured asset.
At least 7 days time just to get the instruction,
first
Milord.
you come and
Yes,
tell me
certainly,
this,
Milord. At
because
1:30, Milord.
there is a question of interim order which will
Malad.
still remain.
Malad.
If the sale is going to take place, then or there are bids which you have received, then in that case, I'll have to injunct the sale from being confirmed.
Certainly, certainly.
That's your lordship.
Milord, at 1:30, Milord.
Auction end is 1:30.
1:30. And that too, my lord, it is not published in newspaper as required under Rule 9(1). I could not ascertain. My learned friend will show. It is only while I was talking to the bank officer saying that, see my deeds, I have given demand justice. You have not responded to and you have physically dispossessed me. My investments are inside the flat in question. I was residing there.
But if there is no EMD, they will not get any bid. EMDs must have been deposited.
Yes, my lord, EMD is required to be deposited before the auction date. I know my learned friend should have had the answer.
Should have this answer now, whether the sale has gone through or not.
Milord, 10 minutes, Milord.
Come at
10
12.
minutes.
12, 12.
12, Milord. Much.
This answer should be there because
Malad.
DOT has to.
Malad. Has to be. Much. At 12, Milord.
Chalo.
My lord, item 39 for petitioner before your lordship, my lord.
My lord, I'm appearing for the UCO Bank.
My lord, I pardoning before your lordship for my personal difficulties. Last occasion, my lord, I could not appear before your lordship. My lord, I filed this writ application before your lordship, my lord, for taking, my lord, my residential property, which property has not been mortgaged to the bank. And my lord, the bank, by suppressing the all fact, my lord, they are, my lord, taking the, my lord, order from the, my lord, landed, my lord, CGM Birbhum.
Property is not mortgaged means what? Your.
My lord, my residential property, which I, my lord, annex, my lord.
Yes, madam, what is the property
lord.
which has been mortgaged? He says you have taken.
There appears, there, no, my lord.
My lord,
There
my
appear-
property has been mortgaged.
Yes, madam.
My lord, from his writ petition, we have found that there has been some fraud committed upon the bank. I would like to place on record certain documents that we have. Because of that fraud that has been committed, their identification of the property is in question. So as of now, we have not proceeded
must
with
be
any
having
other.
Madam, for the purpose of equitable mortgage, you must be having in your possession.
I have the deed. I have the
Now,
deed.
if your
My
title
lord,
deed- if
the
your
deed
title
number
deed-
that.
Let me
My lord.
complete, madam. If your title deed matches with his title deed, then in that case, you may have a case. But if, as it happened in the earlier case, if he has purchased the property prior to it being mortgaged to you, prior to the person who is the mortgager in your case, prior to that purchase, then in that case,
My lord,
your
there is no purchase here. There is no purchase. It is a property has been shown to be as the mortgage property, but a different deed has been presented to the bank.
No, but you will have to
So
take
that
possession of.
we have the deed that
You
we
will
have.
to take possession of that property only.
My lord,
and submit
absolutely, my
matter.
lord. And
Take a different
after
property.
this writ petition came to our notice, we have sent surveyors to identify the
the
property.
agency now?
I will just need
My
a
lord,
week's
my
time, my lord.
agency is that, my lord. Kindly see page, my lord, 41. My lord, the CGM order of landed, my lord. Page, my lord, 41. My lord, the description of property, my lord. All that part and parcel.
CGM order, are you going to implement now?
No, my lord, we are not, because since we have figured this out.
No, my lord, the advocate commissioner, they, my lord, issued the notice.
No, we are.
31st July 2024, taking the physical.
You were also absent thereafter.
Yes.
19th, you were also absent.
Because if
When
there
can you
is.
come back with your instructions, madam?
My lord, and my lord, I would like to
Can you
point
come
out.
back with the
My lord, 1 week. And my lord, one more thing, they have prayed for interim order with respect to both the properties. One which he's claiming that he has mortgaged, and the other that he's claiming that is not mortgaged. My lord, I oppose
that
such
which
prayer
is,
with respect to.
Very well. Likhen.
And my lord will kindly give me leave.
Yes.
Now, page 53, Lordship, the application was filed under order 21 rule 13, Lordship, that the দরখাস্তকারী পক্ষে ডিক্রিদারের নিবেদন এই যে উক্ত উপরিউক্ত মোকদ্দমায় মাননীয় আদালতের ডিক্রির তারিখ হইতে উচ্ছেদের দিন পর্যন্ত ক্ষতিপূরণের ডিক্রি প্রদান করেন। Now kindly Lordship comes to the decretal portion, page 27. Page 27, Lordship, the last two line.
Just a moment.
The plaintiff shall have further. Lordship got the Lordship, page 27. Decree passed by the learned trial court.
27, yes.
The last two line, Lordship. The plaintiff shall have further liberty to realize rupees 200 per day, Lordship, from the defendants on and from the date of, Lordship, the judgment till the date of getting peaceful possession from the defendants, subject to the payment of adequate court fees in accordance. Now, Lordship, this application was filed, Lordship, for realization of the, Lordship, decretal amount, Lordship, which was granted by the learned trial court. This Honorable High Court, Lordship, while dismissing, Lordship, the order 41, it was appealed to the Honorable High Court. Thereafter, Lordship, they did not prefer any application before Supreme Court. Now, Lordship, for realization of the, Lordship, this 200 rupees per day, this application under, Lordship, 2113 was filed for realization. Now, they, Lordship, expressed their inability to pay the said amount. Thereafter, Lordship, people, Lordship, kindly consider the order passed by the learned trial court.
Yes.
Order number, Lordship, 26.
Order 26.
26, Lordship, 23rd of February 2026.
Yes.
The Lordship, last paragraph, it appeared from the record that considering verification of Serestader, I think there is no impediment to proceed with the execution of the decree that has been, Lordship, filed in respect of the, Lordship, execution of the. Let them pay the money, Lordship.
Yes,
Let them pay.
not at all. Now, Willard, kindly see, Willard, Lordship has Willard seen the Willard eviction decree, Willard. It says, Willard, 200 rupees per day. 200 rupees per day. Willard, now, Willard, Lordship will kindly see, Willard, there is no adjudication, Willard, how this amount will, how they have arrived.
That is a part of the decree. No further.
No.
It is not
From
preliminary.
the date of the, where is the date?
Yes,
where is the date?
Date of
We are
judgment
asking-
decree.
Please. Where is the date of Willard? They say till the date of possession. The Willard possession, Willard, we have vacated. Kindly comes to
It
Willard.
is
page
given
51.
on and from the date of judgment. till
Exactly.
The date of getting peaceful cause possession.
Well,
Till the
no,
date of
not peaceful cause possession.
written there. page
Exactly,
28.
exactly. Willard possession was not taken, Willard, by them, Willard, through process of execution.
Whatever it is, if possession was taken, yes, possession is. They have given a date. Last time you showed it to
Yes,
me.
yes. Kindly comes to page 51.
They have
These are all.
submitted.
Please, let me complete.
Yes.
Kindly see page 51.
Page 51.
Yes, Willard.
Yes, page 51.
Kindly see on the middle of the page.
Yes.
Millard, these are all running expertise. Millard, kindly Millard takes it in mind. I was Millard not even given a chance, Millard, to controvert this awardment. I say Millard, kindly see on the ইংরেজি আপিল মোকদ্দমা 22/4/2019 তারিখে খারিজ হয়ে যায় 232 1996 শর্ত মোকদ্দমা রায় ডিগ্রি অনুসারে বাদী ডিগ্রিদার 3/2026 নম্বর জারি মোকদ্দমা অত্র আদালত
Where are you reading, Mr. Bhattacharya? Where are you reading? Where are you reading?
51, Millard.
Page 51, where?
Millard, on the middle, Millard. May I place it from the beginning, Millard?
No.
Millard, just Millard, the date, Millard,
Yes.
of 2006. At the middle, Millard, just at the middle.
Middle, yes.
3/2006, the number জারি মোকদ্দমা, Millard.
3/2006 নম্বর জারি, yes, got it.
মোকদ্দমার অত্র আদালত করিয়াছেন এবং উক্ত জারি মোকদ্দমায় অনেক বাধা বিঘ্নের পর বাদী গত ডিগ্রিদার গত ইংরেজি 17/7/2019 তারিখে নালিশি প্রেমিসেসে দখলপ্রাপ্ত হন। How? I am disputing this date. I was not even Millard given an opportunity to controvert
According
this.
to you, has he taken possession or not? He has taken possession.
I have given possession on the date of the suit itself.
On the date of
on the
suit itself.
date of the
Now,
dispute itself.
they
Now,
prefer-
this is the factual aspect.
Yes, let him controvert. This is one which you have to answer. Yes, next.
All Millard are running ex parte. No application served, nothing. Execution case is also running ex parte. Now Millard kindly takes a order 20 rule 12 whether this can at all be done.
Order 20 rule 12. Yes.
That's when I showed your lordship this provision. Then Millard lordship being satisfied pass the Millard order of stay. Kindly see Millard order 20 rule 12.
Yes.
Kindly see, whereas suit is for recovery of possession of immovable property and for rent or mean profit. The case as the may be A for possession of the property, B rent for the rent which have accrued on the property during the period prior to the institution of the suit or by directing an inquiry as to such rent. B A for mean profit or directing an inquiry as to such mean profit. C. Directing an inquiry as to rent or mean profit from the date of institution of the suit until one delivery of possession to the degree holder. Since the degree holder stated that date, court took it that yes. Number two, the relinquishment of possession by the judgment debtor with notice to the degree holder through the court of the court. Number three, the expiration of 3 years from the date of the degree which even first occurs. Number two, when an inquiry is directed under the clause B, that is here mean profit, or clause C, a final decree in respect of the rent of mean profit shall be passed in accordance with the result of such inquiry. Where was the inquiry? 1. Number 2, Millard, kindly see Millard, subrule 3 of C. In case of Millard, it cannot be more than 3 years. Millard, there is also a limitation. Only because he says that the court took the Millard even both the date and amount as sacrosanct and no Millard copy Millard served upon us. When this order was communicated to police came and intimated us. Thereafter, we took out Millard certified copies and approached before your lordship. 1. Number 2, Millard, kindly see page 50.
50. Yes.
Kindly see Millard. What is the relief paid on the left hand side? 10,200 টাকা আদায় প্রার্থনা
10 লক্ষ
10 লক্ষ
20 bringing his amount down, he will.
Yes. Therefore, the relief is Millard for Millard recovery of money. Millard, this has to be Millard according to the Civil Procedure Code. I'm Millard relying upon these provisions according to Millard execution, just like execution of a money degree. Just like execution of a money degree. Now, Millard, kindly see Millard the application just Millard read out by my learned friend at page 53. Kindly see.
Yes.
Kindly see, দরখাস্ত পক্ষে ডিক্রিদারের নিবেদন এই যে উপরোক্ত মোকদ্দমায় মাননীয় আদালতের ডিক্রি তারিখ হইতে উচ্ছেদের যে দিন পর্যন্ত ক্ষতিপূরণের ডিক্রি প্রদান করেন তদ্বাবদ 10,20,000 টাকা আদায় প্রার্থনা জারির নোটিশ দেনদারের বরাবর প্রেরণ করা হয়। দেনদার টাকা দিতে পারিবেন না বলিয়ে প্রকাশ করেন। আদালতের বেলিফের রিপোর্ট দৃষ্ট তথা প্রতীয়মান হইবে, সেই কারণে দেনদারের পৈতৃক সম্পত্তি যাহার বিবরণ নিম্ন তফসিলে প্রদত্ত থাকা ক্রোক করিয়া নিলামন্তে পূর্বান্তে টাকা আদায় আদেশে হওয়া আবশ্যক। Therefore, he wants croak. Now, Millard, kindly see Millard 2 provision of the Act. Order 21, Rule 42. Yes, Millard, kindly see where a decree directs an inquiry as to the rent or mean profit or any other matter, the property of the judgment debtor may may be before the amount due from him has been ascertained, be attached as the case as in case of an ordinary decree for the payment of money. This is what I was saying. Now, my lord, kindly see, my lord, 54. Kindly see, the mode is given. What is the mode to be followed? Where the property is immovable, the attachment shall be made by an order prohibiting the judgment debtor from transferring or charging the property in any way, and all persons from making any benefit from such transfer or charge. 1A. The order shall also require the judgment debtor to attend the court on a fixed date, or to take notice of the date on the fix for settling the terms of proclamation of sale. Number 2, the orders shall be proclaimed at some place or on adjacent to such property to beat by beat of drum or other customary mode, and a copy of the order shall be fixed on a conspicuous part of the property, and then upon a conspicuous part of the courthouse, and also where the property is in land paying revenue by the government in the office of the collector of the district in which the land is situated, and where the property is land situated in a village also, and also in the office of the Gram Panchayat, in also having jurisdiction of the village. Milord, these are there, Milord. One. Number 2, Milord, as of today, Milord, what was the, Milord, so hurry, Milord, to, Milord, ex parte, Milord, allowing the application without serving me a copy? Milord, I am disputing that there has to be a preliminary decree, and Milord, Order 22, Rule 12, Sub Rule 2, Milord, says there has to be a final decree on that. Milord, why, Milord? Because why they avoided doing this? Because just like that, Milord, Milord, our civil rules and orders says they have to pay court fee just like a money decree on that for realizing of same. And Milord, all these, Milord, draconian, Milord, orders have been passed directing, Milord, officer in charge, Milord, to.
But they say that summons were served upon you, you did not
And they are appearing since
2023.
2023, they are appearing, Lordship.
Let them, Milord, show, Milord, from the order sheets of the, Milord,
Order
execution.
Please see the order impugned itself. That is
And your Lordship,
I have annex.
Lordship, kindly see the order dated, Lordship, 13. They are all along above.
The order records that. How will I disbelieve this? None appeared, as well as per affidavit filed. There is no appeal pending.
Yes, Milord. Kindly see, Milord. Today.
It is someone.
Milord, there were. Kindly comes to, Milord, order number 14 dated 7th of March 2023. Milord, the court, Milord, completely got confused. Summons were served upon, Milord, the pro forma defendant.
Order 14.
Yes, Milord, order number 14 dated 7th of March 2023.
But here, who was the other side who raised formal objection? Who was the other side who was present?
Kindly see the Lordship next order.
Yes, I'm coming to that. Next order is also coming.
Next order.
Maloy Dotto be impleaded as the plaintiff, and Dolon Chapa Podal, 2 other be defended as impleaded as defendant number 225.
Plaintiff.
Sister of the plaintiff, Dolon Chapa, who have been, Milord, added as pro. Then, Milord, kindly see, Milord, the order number 15 is today is fixed for an SRAD.
Judgment debtors are represented.
Next line, no SRAD has been received. Milord, I do not know what. So what?
You appeared.
Yes. And
Next order.
What about, Milord? Let us, Milord, also take it. We appear. Well, what about the, Milord, about the following about the provisions of law?
Next order, Lordship, kindly order number 16. They appeared.
Yes.
SRAD received.
Yes, and what is your answer to this point? Order 20, Rule 12.
Now, Lordship, kindly consider, Lordship, the order 20 rule 12.
Yes.
Where a suit is for the recovery of possession of immovable property and for rent of mean profit, the court may pass a decree for possession of the property be for the rents which have been accrued on the property during the period prior to institution of the suit, or directing an inquiry as to such rent. For the mean profit, directing an inquiry as to such mean profit, or directing an inquiry as to rent or mean profit from the institution of the suit until the delivery of possession to the decree holder. Now, in this Lordship execution proceedings, there was no dispute raised by the Lordship, the judgment debtor, that they are not in possession. They have handed over the possession since 2023. They are appearing. Now they are submitting that they have no knowledge. Police came and for handing over the possession. Since then, they have the accrued the knowledge. Now, from the order sheet of the execution case, Lordship, your Lordship will find, Lordship.
No, what will be your submission to his contention that we have handed over possession on the day when the judgment was passed?
No
Now,
possession.
if that is the case, then in that case the mean profits will be nil, because it is from the date of judgment, not from the.
From the
contemplate several situations. If you see, kindly see B. This is prior to institution of suit. B is
Lordship,
prior
for
to
the rents to have
prior
accrued on
to
the
institution.
property
Prior to
institution of the suit.
PA, again prior to institution of suit.
Of the suit. Directing inquiry, it was Lordship, C.
Then
kindly comes to
C is one
where delivery of
it is
possession
from the institution of suit.
Institution of the suit.
Yes.
Two, Lordship, the relinquishment of the possession by the judgment debtor with notice to the decree holder. Now, Lordship, kindly comes to the Lordship, the impugned judgment and decree passed by the Lordship learned trial court, where it has been, Lordship, hold that the when, Lordship, the alleged disposition was made by the Lordship respondent, and that has been challenged in the appeal and affirmed up to this Honorable High Court, Lordship.
Within 1 month from the date of the judgment, it was supposed to be given to you. Possession was supposed to be given to you.
Given to.
And mean profit was from the date of the judgment till the date of handing over of possession.
Handing over the possession.
His contention is that this inquiry as to from which date to which date this inquiry has to be done, which has not been done is what he is contending.
Now, their contention, Lordship, in respect of application page 51, after appearance, they must, Lordship, file an objection in respect of the Lordship application. For Lordship, the
suppose if they do not file an objection, then in that case, will the court not conduct the inquiry as to from which date possession was given to them?
Now, it was, Lordship, in terms of the Lordship judgment and decree passed by the learned trial
Judgment
court.
says only two things: date of judgment till date of handing over possession.
Handing over possession.
Now, date of handing over possession is in debate. You say sometime in 1999 or whatever, and he says on the date of judgment,
On
I have
that-
given possession.
Now, Lordship, from
How
the
who will resolve this?
now,
Who
Lordship,
will
kindly
resolve
consider,
this?
Lordship, if any objection is not come out from the Lordship side of the Lordship judgment decree,
My lord would
judgment data, Lordship.
see order
Then
number
the
29.
then what will, Lordship, the court will follow?
13th May 2026 order.
Order 29.
Yes. My lord, kindly see degree holder order dated 13th May 2026. Kindly see degree holder files a petition under order 21 rule 13 fixed 8 June 2016 for passing order. My lord, no copy served on the next date. My lord, police.
Now, in
On
respect
the
of,
next date, police.
in respect of the application filed, Lordship, at page 51, what they have done, Lordship, after since appearance?
Page 51 you have served. Show me that.
Yes.
Show me that you have served page 51. Then
51, Lordship, kindly comes to, Lordship, the order number. SRAD has been received, Lordship, kindly consider.
Is already upon the pro forma respondent.
No. Order number 16, Lordship, 17th of October 2023. Pro forma are the, Lordship, the plaintiff substituted heirs.
Order number 16.
16.
No, but this is of 2023. Your application was filed in 2020.
Now, application 51, Lordship, 2020. The execution case was filed, Lordship, 51. At page 51, it was filed, Lordship, 2020.
Yes, but 16, no SRAD has been received.
16 Lordship SRAD has been kindly
No,
consider Lordship.
no SRAD has been received, fixed for such a fixed on such and such for SRAD, and plaintiff is directed to file fresh requisite in the meantime.
16 Lordship, no SRAD has been received. Now
So there was no service. You come back next week. Tomorrow?
tomorrow.
I'll extend the interim order for limited period.
I will regarding position Lordship, I have to look the Lordship decree of the appeal court and
So
Lordship.
instead of tomorrow, I'm fixing it on Tuesday then.
As in Lordship. Please.
No MD. No MD. my lord.
But they will publish it.
At least 15 days time will be there, Millet.
No, what-
Millet, 7 days only for
Okay.
7 days only
Then
for
take-
getting the
take instructions and come back on Monday.
Monday, Millet.
Okay, tomorrow is a day. You need to take instructions only about this. The deed itself, nothing else.
At least till Wednesday, Millet, it will be because
Then in the meantime, you will again publish a notice.
Millet, by that time, Millet, I don't think they will publish the notice. Millet, we haven't received any instruction on that. At least Tuesday or Wednesday, Millet.
Tuesday.
Tuesday, Millet.
So no bid has come.
No bid has come.
ওই ওটা কল করুন দিদি ওনার আইটেমটা কল করুন ব্রিফ দিন
Three flats. Out of three, two flats are somehow responsibility and gone down in this petition. The other one is also in the pipeline. I guess there is no bids on all three. 301, 302, 303, as I could understand from the letter. So the other petition may also be come up on Tuesday.
Whenever the date is.
That I'll take up. I'll take up.
Because your argument is no security interest. That is without jurisdiction. Yes. You need.
At the first call, my lord, adjournment was sought for, she was made it passed over.
Oh, acha. What to do? He may have been held up somewhere.
Next week.
Not today.
Next week, my lord, next Monday.
Next Monday, could do. Not this week. Next. Okay.
Lordship, in item number 15, I'm for the petitioner. Lordship, on the last occasion, there was a direction upon us to file an exception. Lordship, may I hand over a copy to them?
What is the matter, madam?
Lordship, this is regarding the illegal diversion of the high voltage electric line over the petitioner's private land, Lordship. Lordship may kindly fix a date. Because my senior.
With deepest respect, I humbly submit. If you no, I am
Senior
not on
member of the
time.
bar, she seeks time.
I am not on that, Lordship.
Lordship,
Kindly see
at-
the last order where there is a direction to add the BL and LRO as a party.
have already
Panchayat authority as a
added them,
party.
Lordship, and Can 1 has already been disposed of, Lordship. At this point, Lordship, there is only a limited prayer.
They have added.
So
But I
that-
don't know whether copy has been served or not. Copy served?
Has copy been served on the
Yes, Lordship.
affidavit of service?
Well, file it in the course of the day, Lordship.
ठीक है. Junior member of the.
No, I am not on that. I am just.
Now for the petitioner.
I am appealing to the price.
I am for CSC authority.
On the last occasion, with regard to the unauthorized construction, Lord, I have produced a document in respect of unauthorized construction wherein a
What is your instruction?
direction was passed.
My lord, I will answer all his queries. But before that, I want to know something from my learned friend. First of all, I want to know who he is. What is the locus standi? What is his locus standi and how did he procure that?
You first tell me whether this stop work notice still subsisting or not, and what is the status of this?
My lord, the status of the stop work notice is that it was filed long back and the matter has already been resolved. At present, there is no unauthorized construction. Here is the one of the letter, my lord. What my learned friend have sent to the concerned authority, and there is something more to it, my lord. Even if we speak about the subsistence of the stop work notice is concerned, may I place this judgment of the coordinate bench?
May I have a copy to that, my lord?
I will love to. I will definitely give. Is it Dr. Epidina? My lord, kindly see paragraph 3 of on page 4. Excellent.
Yes, sir.
Yes.
Lordship, may
And the mother judgment from which this particular order is. I will give you. Don't worry. I will give you.
Lordship, may I have a copy to that, my lord, which he has produced
Copy of
before?
what?
This
Copy of what?
instruction, my lord, which he has
He has
produced.
handed up to you.
No, nothing. Only one copy has been handed.
Not required. That copy you keep with yourself, not required.
My lord, I will not disturb your lordship. I want your lordship to go to the judgment first.
Yes.
And my lord, there is something more to it.
Yes. What is your response to this judgment?
Lord, I don't have a copy.
I know. Have a copy. If you don't have a copy,
Lord,
ask
first
for
of all,
your,
my lord,
for it from your learned friend.
Lord, first of all, I would like to respond to this letter, Lord.
You don't have to respond to that. You first respond to the legal point. Forget that. Let us assume there is a stop work notice. Please read the judgment and answer the point.
My lord, may I say a few more things?
Wait. Yes, sir.
My lord.
Yes.
I urge your lordship to come to annexure P4 of my writ petition.
P4.
Yes. Paragraph 2. The team deployed to execute the job were unable to do so due to objection raised by the inmates, as well as the access supply position was denied. My lord, I was going through the Electricity Act and I was taken aback to see the expression inmates is nowhere being described in the Electricity Act. As such, I am asking my learned friend to whom he is representing. Number one. Number two, the stop work notice, what he has asked on last occasion, I am eager to know from which source he has obtained that.
That is not relevant.
He has completely misled the court.
Don't argue things which are irrelevant for the purpose of the present writ petition. Argue your point. You are entitled to.
I have produced the record of rights. I have shown the deed.
Sir, what is your final answer?
Yes, sir. Lord, this is in respect of where the connection was given in respect of
that is not a distinguishing feature. Very well.
Lord,
I have
this is
taken
not
your point. Yes.
First of all, my lord, if your lordship can take pain to their, this is the document which they have produced.
I am assuming that there is a stop work notice still existing.
This was issued.
I am assuming that there is a stop work notice still existing. Now proceed on that basis and argue.
Yes, sir.
That is your best case.
That is my
best
best case. If there is a stop work notice is issued, this construction.
Does the stop work notice equal a notice for demolition and order for demolition?
No, that does not constitute as a demolition, my lord. But you lordship kindly allow.
Enough time has been wasted.
On the last occasion, report has been filed.
Yes, my lord. It has been.
Your lordship kindly take pain to. This is the letter of.
I am not taking cognizance of that letter. I will deal with your stop work notice.
Lord,
we have already wasted enough time. This is the third day. Now please dictate me. Let me dictate the order. You don't have any substantial point. You have done your bit. If you have anything in substance to argue, please argue that. Don't repeat everything, the same thing over and over again. You have been doing that only.
Lord, I am not debating. What I am on before your lordship, Lord, this case has been filed entirely on the suppression of material fact, which is before your lordship.
CSC authorities have conducted inspection. They have found that there are tenants who say that he is his landlord. He is in possession of the property through his tenants. He is the owner of the property. There is prima facie document on record. If you dispute the ownership, it is for you to go and get it settled before the competent civil court.
Yes,
this is not the forum. If he is the owner under section 43 of the Electricity Act, as an owner, he is entitled to it. As an occupier, he is entitled to it. Your stop work notice does not stand in view of this coordinate bench judgment equivalent to an order of demolition. So there is no
I
case.
am not saying so, but my lord, your
Wait
lordship,
for your
can,
lordship.
my lord, may I answer to your lordship's query, my lord?
I did not pose a query. You have already answered. I was answering to your doubts.
No, your lordship. May
I asked for
my lord,
police
with-
assistance, your
my
lordship.
first, with regard to that, my lord, your lordship, whatever fallen for my lordship, my lord, first, with regard to that, my lord, first is that, my lord, with regard to unauthorized construction. My lord, unauthorized construction, that there is a stop work notice that is admitted, but my lord, if your lordship can
Neither
see
here nor there. That is why he
report
brought
filed
the
by the
coordinate point
report
judgment.
filed by the company, which depicts that, my lord, this says that, my lord, there is a tenants.
So,
but my lord, with no
what?
Sir,
My lord, I
what?
challenges Lucas.
This was
I
already
challenges
argued last
Lucas.
time.
Who is he to
This
stop
was
say
already
that?
argued last time to the hilt. You had taken time because you had shown a stop work notice to which he wanted to answer. He has answered that. So let us start from that point. You are again going.
I am
that is why
starting from that point.
No, you are not. You are repeating.
No, no, no. Not I am I am on the point that, my lord, the electricity board has said that, my lord.
Tell us when you complete.
No, no. Just give me one more minute. Not I since not only thing is that this is that, my lord, they are a tenant, and that is from their report it depicts that, my lord, the tenants are from belongs tenants. Sorry, lordship, the tenants of the petitioner. My lord, there is no document to show in this court, my lord, that they are the tenants of that person. First of all, it is my humble submission. My lord, second thing, with regard to the house is concerned, there is no document to show before your lordship that that house is constructed by that person. Because there is a stop work notice, there was no illegal construction.
And who are you? Who are you?
I am the adjacent plot owner. Moreover, my lord, that is
plot owner is enough. Chale. The writ petitioner.
no document on record that has been produced, my lord. Are only
I have recorded it.
and with
recorded
regard to the
record of
judgment,
right is there.
the distinction which have
Next matter.
judgment is not applied to this case also. হ্যাঁ, করবে। হ্যাঁ।
Yes.
Milord, I am for the petitioner, Milord. Milord, kindly have a look in para number 9, Milord. Milord, the said house was confiscated by Canada Bank, and for many months petitioner was not in the said house. After settlement of the said dues with the Canada Bank, they came and they saw there was no electric meter.
My lord, before my learned friends submit, one thing, my lord, I will not. We are, my lord, this is a theft case. We have given case in the Sikha Das, son of Bubai Das. Now, who is Obhijit Das? We do not know. Why
Bubai
Obhijit Das has
is
filed
no
this writ
one.
petition?
He is the caretaker kept by the said bank. Obhijit Das is son of Shikha Das, Milord. We have strong objection in this that Bubai Das is no one. My Milord, kindly call for a report from Dashnagar police station. As they filed the criminal case, we made the acceptable bail application, and police has submitted the report that Obhijit Das and Bubai Das are not self-same person.
So, therefore, how my learned friend is prejudiced? We have
Milord, I
given
am the
case.
son.
What is your problem?
Milord, they have taken away the electric meter. I am without electric meter,
Apply
and
for fresh electricity.
Who is he? Sikha Das is there.
Milord, he
the
is
original
very much
consumer.
old. I am the son, Milord. Milord, a
Son of whom?
of
Son of-
Shikha Das.
Shikha Das has already got a connection, he says.
Yes.
Milord, there is no connection.
No, no,
The
that is
meter
due
has
to
been
disconnection,
opened.
due to theft.
Milord, how theft, Milord? From 2025, we are out of the house. As by
My
the
lord, kindly
Milord,
see.
kindly see page para number 8, Milord.
Yes, para 8.
Milord, on 8/1/2026, we settled with the bank and entered the house.
That is subsequent. We are not on that.
Milord, we
Sikha
are
Das
not in the
admitted.
house.
Please wait. Both of you can't argue. Yes.
Sikha Das admitted.
Milord,
He is being
we have
approached.
challenged that letter, Milord.
So that's different.
Where have you?
Milord, kindly see how in the last para of the page of the said letter, inside it is written, we have not given any letter, Milord, and it is not our signature.
That writ court will not decide.
This is submitted by Sikha Das, the original consumer.
Sikha Das is bedridden.
That we do not know. The office has
Milord,
received.
a professional Milord, in page number 11, a provisional assessment bill has been given of 2 lakh something, Milord, but we have not utilized anything. We have not make any pilferage, not made any theft, because we are outside of the house.
If there is an order, you have to challenge it before the appellate authority.
My lord.
Yes, Milord.
Final order of assessment already made.
Till such time that the order is set aside, you cannot pray for an electricity connection. Why did you not challenge it?
Milord, we did not communicate it.
You have annexed it to the writ petition. How
Yes,
did you-
Milord. After that, we entered. We
When
got a
when you
copy
got-
from the
when you
agent.
got copy of that, you could have approached the appellate authority. Final order of provisional order of assessment has been passed. Final order has been passed.
Milord, no final order is communicated to us, Milord. We got
He
no
has not
scope.
he has not filed any objection.
We have
Provisional
approached-
assessment we treated as final. That is there. That order is there. That we will supply to my land expense. He has not
Right,
filed any
so
objection.
that he can
Yes,
challenge
yes,
it
yes.
before the
Yes,
appellate
yes.
authority.
Nothing has been communicated.
It will
Communicated.
supply to you from the date of supply within 30 days.
Yes,
you
yes.
Prepare appeal
Yes,
before
yes.
appellate authority.
Deeply.
Your lordship.
The petitioner.
ये देखिए।
Madam.
Yes.
53, my lord, I appear on behalf of
53.
WBAC. That is fixed, my lord. 53, 57.
My lord, I am for the
State.
petitioner. Lordship, last occasion, Lordship was pleased to pass an order, my lord, to file an appeal in opposition. The order passed on by the Lordship on 12th August 2026. My lord, the opposition supposed to be filed on 19th. But my lord, they have filed on the 21.
24th.
On 19, I have affirmed on 19, the service
I-
was 2 days late.
Yeah, I am paying, my lord, whatever, my lord, I am paying extension of time to file evident reply.
It's ready now.
I have served,
Served, my lord, we have received it last Monday. And my lord, I am paying extension of time to file my reply.
দেখি কারা কারা আছে
24th.
লিখে নিন
করেছে।
হুম?
24th.
24th.
Lordship, I appear for the petitioners. Lordship, I was seeking extension of time to correct add the name of the respondent and to affect service once again as per the last orders.
My lord, appearing for the IPCL. IPCL has gone into resolution. I would file my
That's why we
Wakalat
were
reply
seeking for
today.
amendment of cost title and service on the IRP.
Yes, it was directed.
It was directed, just seeking time for 2 more weeks to complete.
My lord, he's just one small submission. My instructions are whatever claim he has had, that has been already submitted before the RP and the COC. So perhaps
This
nothing.
petition may not be maintainable.
Yes, so
Lordship, I don't have those. Let me keep it. We'll file it because this is still maintainable, even in that event also.
Let him
We'll argue that.
লিখে নিন
May I file my supplementary affidavit and the exception to the report filed? Lordship, there is nothing much to say, Lordship. I am serving. Email I'll serve a copy. Lordship, may I file the... Lordship, what has happened in the meantime, Lordship, there has been an inspection carried out pursuant to the order by the coordinate bench, Lordship remembers, where the Haldia Development Authority, Lordship, the Haldia Development Authority has found out that there is no occupants. Lordship, in my, may I serve the copies also?
Let us come back, on Monday. Let us consider it,
Lordship, there is nothing much in the exception report except for the documents that was annexed to his report.
Let them consider.
Lordship, I do not think my learned friend will
Exception, my lord, I don't have any problem. It's my report, my lord, exception which my lord has been used. But my lord, supplementary.
Supplementary, there is nothing, Lordship, with the same documents. What was alleged in my supplementary affidavit has been confirmed at the inspection held yesterday, Lordship, day before yesterday. Lordship, that has been found that the HDA has found...
Instruction, my lord, I have not been served with the supplementary affidavit.
Supplementary, it was everything has been served by electronic mail. Lordship, the... At you, sir, আপনার email address এ পাঠিয়ে দিন and দেখে দিচ্ছি আরেকটা কপি দিয়ে দিচ্ছি আপনাকে তাহলে
Madam, complete this service. I'll come.
Very well. Lordship, kindly record the service of the
exception to the report filed on behalf of the respondent number 2.
appearance.
Monday date ta diye deben. Monday naam na likh 31st August. Next.
For the private respondent.
Was not as report was directed to be filed, but I believe the report has come. But, now, may I ask for a copy of the report because I do not know what has come in the report. I only know the status of the facts that is there.
Waited to report
Both of you could not show any alternative way.
But the alternative way, so far my instructions are concerned, were shown, where road was shown, an area was shown through which, my lord, they...
To be feasible for them.
Yes, that is
what maybe as layman's we may find alternative way.
Yes, that is
but
true.
The experts will have to...
That is true. The electricity department has to find. I cannot take risk of accidents. But may I consider this and come back? If your lordship kindly allows me to use an exception if necessary. If necessary, I say.
Exception was conducted in your presence.
It was conducted in my presence. The minutes were drawn up later on, and the report is certainly not prepared in my presence. My lord, I'll have to look at the report.
The report is usually not prepared in presence, but the gist of the report must have been made known to you. Is it your case that in front of you it was agreed upon that yes, this is the alternative way through which
but
the
what I am instructed, I am instructed that an alternative way was shown and the private respondent as well.
Understand, there are two things. You may have shown the alternative way.
Yes.
Was it agreed that yes, this is the alternative way through which we will take?
But that has to be, I have to take instructions because this alternative way was shown cumulatively by the petitioner as well as the private respondent.
Already recorded in the order also. They have recorded that the alternative way is not feasible. They don't say that you did not show.
But it cannot be a pond because
we cannot draw the line because in case of any windfall, there may be a chance of electrocution.
At every
we
moment,
cannot
if it is a pond, then it is also not my case. My case is
mandate the safety measures to be taken into consideration.
That is without doubt.
Being carried to the private respondent.
But that there is only one way out. That the line which has been drawn there, from there we can draw that line. Otherwise, it is not technically feasible. It is very difficult.
What I say, my lord, it is not.
And they are not allowing us to draw that line from that place.
It is not the pond that I have indicated as alternative way.
Draw the line. It is in his possession.
Yes, it is in his possession. I tell you, lordship, there is a one one house where there is an existing electric line, and this line has been drawn from the where it has been drawn from the beside the premises of the petitioner who is objecting. Now at this juncture, we have made a joint inspection and we have told them to show us a one place which is technically feasible. They are showing us, I am also carry the video, that there is a pond through which we have to draw the line. But it is not technically feasible. We cannot take chance. In case of any untoward incident, then they will make us responsible.
I am also not making any submission to the effect that the electricity has to be drawn through a pond. But I am saying there is an alternative way still, apart from taking the wire through my house. My whole objection was that the wire was intended to be taken through my house. But my house, I have a children, I cannot visit the rooftop. I cannot do paintings on the wall. I cannot do anything on the wall. If the wire is drawn through the wire, is drawn through the wall. But apart from the wall, there is a separate way. I'm not saying that is the pond. I'm saying that there is a separate way through which the wire can be taken without disturbing my residence. That is my whole case in the petition.
The picture of his house, outer wall of his house, and 2-3 houses already have connection through the same path.
But that cannot be a defense if your lordship kindly takes up the rules.
We have also wrote letter to the private respondent to get back the money if the technical feasible position could not be shown. Because we are not in a position. It is our predicament, lordship. Kindly appreciate.
But they
are still objecting. They are standing on the way. We cannot draw the line.
There is space between two constructed houses through which electric lines can be laid. Their whole intention is to draw the line through my house, only by affixing an angle on my house.
Is your house, say here?
But I'll have to look. I'll have to see. This
I have
photographs I'll have to see.
Sketch map I have given.
From this, it is difficult.
I have drawn a sketch map. If your lordship kindly see the report also.
Yes.
In the inspection report, a sketch map has been drawn probably. Your lordship will see in the pond here that they are showing that this is the where we can draw the line. But this is not technically feasible, lordship.
This is
your there is a pond, yes.
But this photo has been shown to.
Eta oder house to. From the sketch map, which is as
you want to take overhead this from the existing pole directly to
respondent. I can clearly see a common passage.
Your lordship, there is an existing pole. Lordship, kindly see it has been given from where we can draw the line. But apart from that, there is a narrow path, very narrow path. They are showing this path which is neither technical feasible, and from the pond it is not also technically feasible, because safety measure is to be taken into consideration. Even if anything happen, in case of a windfall, then we'll take
this narrow path you cannot draw.
There is a difficulty. It cannot be done. I have talked with them, but it cannot be drawn, lordship. It's a very risky.
Madam, you showed that the others are getting. How are they getting according to this map?
May I just indicate one more thing?
My connection, lordship, through his outer wall of his house.
Through the outer wall of my house. That is all he claims.
From outer wall of the house.
Outer wall of the house, kindly says it is attached to the wall of my house. Our house, the wall which is brick wall.
Even before my residence, lot of wires go.
Yes, it can go. It can go. It can go, but without any angle attached to my house. If your lordship kindly looks at this, kindly looks at the picture, there is a narrow passage between the square marked as other house and the house of Shumnath Das, the petitioner.
It is not one way. It is not one day's work that they will just string the line and business will be over.
But here
suppose some defect occurs at any point of time and they need to take corrective measures. How will they mend the wires?
But that is why. Yes, I absolutely bow down. In fact, that is my whole submission even. The electric wire cannot be run through this narrow passage. What I submit is, if your lordship kindly sees, there is a common passage indicated in the diagram. There is a common passage. There is no existing pole there.
A narrow path.
But there is a common passage through which leads safely.
Passage is the narrow path.
Very narrow path.
It is the same thing. It is not something different.
If it goes through the common passage, otherwise,
you are confusing the narrow path and the common passage.
These common passages, I am told this common passage is more than 4 feet wide.
This common passage is used for daily ingress and egress.
Mr. Sahara, if
But,
this is more than 4 feet wide, it is
motorcycles are run through this common passage. Motorcycle is running. If anything were fall down from their place,
That happen. That may happen on any street.
Incident, Lordship, elaborate
happen on any
inspection
street.
has been taken
that
place.
is no ground. Wire falls, it can fall from even a wide.
I understand, but there
That
is an
is no
existing
answer.
pole. If your
This is
Lordship
more
thinks
than
that
2
have
feet
problem,
wide.
Wide is sufficient. Why? What is the problem?
whether it is technically feasible or not, because I am not an expert, Lordship. I cannot say.
What is the reason to say that it is not technically feasible? Unnecessarily, this person will be without electricity.
We are
He is
trying.
also right in saying why should he allow electricity
But
connection?
there is
always to be
already an
taken through his
existing
house?
pole. There is an existing pole from that place.
Maybe the existing pole does not mean that you have to take it through his window. That does not.
No,
mean
I am
that.
not saying that, Lordship. Lordship, kindly appreciate the situation. If it is technically the expert body, we have got the intention to
Why
grant him
don't
the
you take
electricity.
it? Why don't you take it through the abandoned house? There is an abandoned house at the side of his house.
This is other.
This is the abandoned house. There is no such place, Lordship.
Yes, you have written it in the map in your map.
Yes, yes. In the abandoned house, if your Lordship kindly see, if you have to draw this, the pond is here, Lordship.
No.
Through the
abandoned house has two walls. The wall which is at the side of the petitioner, why don't you take it through there?
Then I have to take instruction on
Take
that.
instructions. If any additional cost is to be borne, the private respondent will bear the costs. We have to think of a solution.
Lordship, we are trying. I have talked a detailed discussion whether.
So therefore, you in your details you include this also, abandoned house.
I will talk
this.
I will talk that whether it can be drawn from that abandoned house.
Maybe some more electrical appliance or some device may have to be installed there. They will do that. They'll bear the cost if they want electricity. But it can't be a strict no situation that they won't.
I will talk two issues, Lordship. So far, the narrow path is concerned, whether it can be drawn from here or not.
All these matters, Dr. Sahara, we should not take it as adversarial. These are all.
No, it's inquisitorial. I understand, Lordship. I understand, Lordship. But I try my level best to grant the electricity. I try my level best, your Lordship.
If there are two private warring parties, that is a different.
I understand, Lordship.
Report filed on behalf of the
private respondent ছাড়া তুলবে কি করে?
21, my lord, I am for the petitioner.
My lord, I appear on behalf of the WBSCDCL, my lord. On the last occasion, I have filed my affidavit in opposition, my lord.
My lord,
I appear on behalf of the private respondent and I'm filing my affidavit.
my lord, I am not intended to wasting the valuable time of this honorable court. That is why I am not giving any reply by their opposition. My lord, in their opposition filed by the private respondent 8C, paragraph 8C, they admitted that I am in possession. Kindly see.
No copy of the affidavit in opposition of the private respondent is
not required. You are an opposition. You are already opposing the writ petitioner.
Kindly 8C.
8C.
Yes, ma'am.
Yes.
C. Said dag number in the joint possession thereof. A narrow common passage, and then, my lord. Now, my lord, kindly see in my application, annexure, my lord, P2, page 14. No objection certificate from my father-in-law, Nimai Shatra. And they admitted that this Nimai Shatra is in possession. And I obtained no objection certificate from Nimai Shatra. And I am lawful occupier of this land. Now, my lord, my one fault, that was, my lord, on
P2, where do I find Nimai Shatra?
No, may I make the long matter short? Kindly
Page 14,
come
my
to
lord.
this will go before the district magistrate, my lord. Kindly come to my opposition, page 4, paragraph C and D.
Where is your opposition?
My lord, I have filed on the last occasion. The petitioner claims possession of the property from Nimai Shatra. Page 4, paragraph C and D. He has given no objection from our father-in-law, Nimai Shatra. Kindly come to paragraph C, my lord, where we have the objection which has come up from the opposite party names Nimai Shatra, Debesh Shatra, and Shoshi Shatra are the multiple owners. What we have to do, my lord, we have to, my lord, draw a 11 kilowatt high tension overhead line and an erection of DTR substation. That was obstructed by the private respondent, stating that there are multiple owners, only one owner has given no objection, so you don't do it. We have annexed all the documents. This problem is in respect of way leave. My lord, will kindly come to my opposition, my lord. The paragraph, page 6, paragraph 8. This is the problem which we are facing. If it is in dispute in respect of the property, my lord, with deepest of humility, my lord, paragraph 8.
What is DTR?
Distribution substation and high tension and low tension line erection.
The TR, how will
distribution substation, DTR is the
where is sub? S, where is S?
The DTR is distribution substation. I will find it out and tell. This should go before the this should go before the district bench. I'll tell
But you first tell me DTR, otherwise I will not send it. Yes, sir.
My lord, I am in possession, my lord. My father-in-law is
not that simple.
Distribution transformer.
Transformer.
Yes.
So why are you saying substation?
Distribution transformer.
Yes. Yes. See, it is not in dispute that you also co-own the property along with the others. Now you want a transformer to be installed. It is not a simple electricity line being drawn to your premises. Transformer to be installed on a place which is owned by more people than one. It's not only you, maybe 2, 3 more. 3 more is what he has shown, Mr. Mukherjee. So if it is owned by 4 people, only you want a transformer to be installed on a common place. Their objection is definitely something which is material. So the district magistrate will chart out a way. He is the authority under Rule 3. Rule 3 is the rules. Rule 3 of works of license is rules. He will find out a way for you.
If I may interject, my lord, what has happened, my lord, they have received a no objection certificate to start business at premises situated at Dag number 154. However, my lord, the trade license is of Dag number 200, my lord. And there is no business.
Then, my
my
lord,
lord, may kindly
yes, my lord, I have the supplementary affidavit, where, my lord, I obtained, my lord, the trade license on the plot number 154, my lord, because I, my lord, applied the connection on the plot number 154.
They've applied for it. They've not granted, my lord. They've not gotten the trade license.
Trade license you have got for 154?
Yes, my lord.
Where?
Supplementary toke দেয়নি?
Supplementary even I have not got. He is giving me now.
I have got it. my lord.
Yes. You give him also because he may have something to say. Yes. Tag 154. Actually, this trade license at a particular premises will not show occupation, because trade license is only the license to continue trade. You can continue it from a footpath also.
Then, my lord, one
Doesn't mean that you are an occupier of the footpath.
Then, my lord, one thing, what in my earlier trade license, I am the owner. I am the owner. Dag number 200. 200. They may be given
200
electricity connection. I, my lord.
But the kind of electricity that you want, for that he says a transformer, distribution transformer is to be installed. You don't want normal electricity supply. He says that there is high tension supply which is to be stepped down by a transformer which requires a space. So in your DAG, if you can, Mr. Mukherjee, if he can provide the entirety of the space in his DAG, what is the problem?
But the difficulty is that 63 kVA minute which is there, that is heavy loaded. Kindly come to page 3 of my opposition. Paragraph B, we have explained why we want to go for 11 kV high tension overhead. Paragraph B, page 3. May I read? It is further stated that existing distribution transformer catering to the locality was recently augmented from 25 kVA to 63 kVA due to severe overload condition. Due to heavy existing network loading, feeding the petitioner's applied commercial load of 10 kilowatt required the creation of additional distribution infrastructure, including the drawal of 11 kV high tension overhead line and the creation of new DTR substation along with LT support poles. Otherwise, we cannot do it.
Difficult. I'm directing you to the district magistrate. The district magistrate will decide. You make a proper representation there in terms of rule 3 of the works of licensees rules. The petitioner alleges inaction on the Yes.
Your Lordships, kindly, if I could only mention one matter, Your Lordship, it's not a company matter, Your Lordship. It's a probate proceeding, Your Lordship.
This is appellate side going on.
Lordship, this is
PS for the petitioner. Let this matter go out of list. Next. Same order.
I appear for the respondent distribution company.
ওনার নামটা লিখে নিন. Go out of list. Next.
94.
$195. Yes, Mr. Naik, you are appearing in 195. Appear করছেন কিনা? Yes, Mr. Naik, please tell.
My lord, kindly allow me 1 minute, Lordship. 1 minute. I am a bit puzzled, Lordship. My lord, it's a case, my lord, against the order of Ombudsman, where there was, my lord, a delay for about, my lord, 616 days. So, my lord, a word was made. Huh? 194?
Who is appearing for the
we are covering.
ombudsman? Who is appearing for the ombudsman?
Lord, I don't find anybody today.
Not today. Please serve notice on them. Next week it will again appear.
I have prepared a brief notes of argument in the matter.
On the next day. চলো next call করুন. $196 দেখি.
Yes, Lord, I appear for the respondent, my lord, here, WBSC DCL.
ওই same order করে দিন. Let it go out of list. ওনার নামটা record.
I am for the respondent, Lordship, in this matter.
Yes, yeah, I'm recording your name. It is going out of list. Unnecessarily, I'll not
Lordship,
keep
Lordship,
these matters pending. Nobody is appearing and
Yes, এই নামটা দিয়ে দে. নামটা দাও.
none appears for the petitioner. Let the matter go out of list. Huh? Same order.
Yes, Lordship, I appear for the WBSC DCL, Lordship.
Please give your name. Please give your name if you are appearing. Telling me will not do because he
What
has to
happened,
record.
Lordship, this heading, today hearing would be taken up, my lord, is very particular. But we have not thoroughly, my lord, gone into it. Hey, 198 there.
Same order.
So 198, Lordship.
Mr. Naik, please give your name. Don't tell
No,
me.
198, Lordship, we are the petitioner, Lordship. I am the
You
petitioner.
are the petitioner. You are appearing. The other side is not there.
একটা date দিয়ে দিচ্ছি। ঠিক আছে? Sub
What is this matter against Mr. Naik?
Lordship,
কত হয়েছে এটা?
90.
In this matter, Mr. Shaha is appearing on behalf of the Ombudsman. He is not come today for his personal difficulties. 198, 195, 193.
No, not today. Next. হলো তো 198 আবার কি
198. My lord. 198, Lordship. 199, Lordship. This is also our appeal. Here, my lord.
Hey, Mr.
198
Saha,
also
the
here.
bill not today, not today. Next.
Not?
Next.
That rules.
Same, not today.
अरे दे
200 তো আপনি আছেন
Not today, not today. Cholun, cholun, cholun.
What a lordship, lordship. I appear for the.
My lord, I'm praying for not today, my lord. I'm praying for not today.
Not today. Next. Out of list করুন 202. None appears for the petitioner. Let this matter go out of list. None appears for the petitioner. Let this matter go out of list.
102.
Next.
Hey, ये दिखाए ना.
Out of list. Same. Next.
Oh, Lordship, I'm praying for 2 weeks adjournment, Lordship. 2 weeks adjournment, Lordship.
Why? Not today only. Next week it will be called again.
Lordship, next week I have some only 2 weeks, Lordship. I will.
Matters you all keep on pestering, and when it comes,
Lordship,
not this week.
I will not be here in next week, Lordship. Kindly 2 weeks. The next date I will, Lordship.
Very well. Next week you pray for adjournment. If you are not there, somebody will pray. I will grant.
Lordship.
Next.
My lord, I'm for the petitioner, my lord. My lord, I've communicated there was an order for exchanging the written notes of argument, my lord. The previous order was that I've exchanged the written notes of argument, my lord, but they have not served us a copy of the written notes of argument.
The respondents are not represented also, not today.
My lord, kindly fixes it on some other day,
It
my
will
lord.
be appearing as and when you keep a watch on the list. Any day it will be shown as on 2 p.m. Maybe on every Thursday or every Wednesday.
My lord. Oblige, my
Yes. Next.
lord. My lord, my respondents are here, my lord.
Yes. Here.
They were Josh, 130.
Also listed ঝুলে থাকে মামলাগুলো। Yes.
My lord, I'm the petitioner. I'm the absolute owner of a 12 decibel land, my lord. My lord, on the land, my lord, the land is being used as a corridor for a 132 kilovolt of transmission wire. And my lord, I have made representations to that effect that I have an objection to that because I'll not be able to. My lord, I'm led by Mr. Abhishek Haldar.
Lord, my homestead land was utilized as a corridor for high tension wire. Well, as regard to that, well, initially I had filed a writ petition. Take us. To oppose the same when I had come to know of it. Well, the writ court said that I had come too late in the day. Hence, what I'm only entitled to is the compensation. That was by a concurrent bench. Challenging that, my lord, we went to the division bench. Division bench affirmed the order of the Honorable Single Bench. Well, then we filed a representation for compensation. And my lord, the concerned respondent authorities said that since they have not acquired the land, we are not entitled to any compensation. There's no actual damage. That was their reasoning. Where is that order? Impugned order. My lord, will kindly come to page 30-31.
What is the order which you are now aggrieved by?
I'm showing that, my lord. My lord, page 30.
Page 30. Yes.
My lord, here it says, my lord, in compliance with the order passed by the Honorable High Court at Calcutta 27 such and such, respectively, myself and the additional engineer and in charge of Malda such and such zone conduct hearing on 16th October 2023, 14 hours, camp office during the presence of the authorized representative of the petitioner and the respondent. During the course of the hearing, both Shri Debabrata Sarkar and Srimati Niyati Sarkar demanded 1 crore compensation amount for conducting stringing work between the tower location such and such. They were already requested to produce quantum of actual damage, and during the hearing, write out letter dated such and such respectively. However, they failed to produce any supporting documents to substantiate their claim. The authorized representative in WBSTCL and representative is a turnkey vendor executing the project submitted that as per survey of the land of both Shri Debabrata Sarkar and Srimati Niyati Sarkar for stringing the conductor 377 square circuit between the span of tower locations such and such. The petitioner submitted a letter during the period hearing mentioning that the valuation of the land is 85 lakhs with necessary supporting documents with a demand to claim the market value of the said land. Now, during the execution of the conductor stringing activity, there were no crops, trees, plants, etc. over the said land. Only a temporary shade made of corrugated asbestos sheet and supports were that they were the said plot. The conductor stringing activity was executed without entering into the land of the petitioner. Hence, no physical damage was made to the respondent authority to any crops, trees, plants, and temporary structure on the land. So there arises no question about to calculate any compensation amount in consideration of damaged crop, trees, plants, etc. as per rate charts of West Bengal Forest Department, Agriculture Land and the Department. So as per clause 10D, the telegraph, the compensation amount comes to nil for the area in between tower location such and such underneath 134 kV, and no legitimate demand of compensation has been raised in this particular case. So, my lord, the reasoning 10D, my lord, আমি বলছি
দিদি টেলিগ্রাফ একটা আছে না আমাদের
না my lord, আচ্ছা আমার ইয়েটা কোথায় রিপোর্টটা ভ্যালুয়েশন রিপোর্ট So now, my lord, what has happened is page 82. My lord, at page 82 is my valuation report. This is the valuation report which I had submitted. My lord, how the authorities have blown hot and cold, that my lord will find transpiring from the order.
But an order passed under section 10D is saleable under section 16(3).
My lord, I'll say what has happened. As regard to this, my lord, we had challenged that order in 16. This particular, initially, we had challenged under section 16D.
This 2nd November 2023 order.
This order, my lord, which I had just read.
Yes.
Initially, we had challenged. And that, as regard to that challenge, my lord, 79, the concerned court, the concerned civil court, my lord, over here, the 16D, the forum is, my lord, maybe it's the 16D. 16(3), my lord, will kindly come to the Indian Telegraph Act. It says, if any dispute arises concerning the sufficiency of the compensation be paid under 10, it shall, on application for the purpose either of disputing parties, the district judge, within whose jurisdiction the property is situated, be determined by him.
How could this be treated as a plaint?
My lord?
How could this be treated as a plaint?
Exactly, my lord. Exactly, my lord. So, my lord, that now this court.
It is not to be determined as a suit.
Yes, my lord. This is not a suit. Exactly, my lord got it.
16(3).
My lord got it. This is not a suit. So, my lord, this was not a suit, and it's an appellate forum.
It is not a question of return of plaint.
Yes, it is not an appellate forum.
But
It should
Sampati
be,
order.
my lord, like reference case under
My lord,
LA.
Yes.
Yes, it should be reference under the LA and district judge has
Huh?
ample power under section
Page 80.
16D to decide them.
Now, my lord, what happened is, challenging, selling that order, I come before the revision court of this court, the revisional jurisdiction. The revisional jurisdiction said that as regard to this order is concerned, this, my lord, will find at page 80. The revision court carved out an exception for me, saying that granted me a liberty to challenge this order in the writ court. At page 81, my lord will find the order impugned is an appealable order. The petitioners are at liberty to prefer an appeal from the said order in court. However, the right of the petitioner to approach the writ court challenging the decision of the chief engineer passed under section 10D of the said is also kept open. So, my lord, I was swinging from one forum to another. My lord, I can't be rendered remediless. My lord, the observation of the district court was that since it's a nil compensation, my lord, how irrational the justification was, well, just because it's a nil compensation, I'm not entitled to invoke the benefit of 16D.
Then what happened to that order of the district judge? Have you carried it up in appeal?
No, my lord, in revision court had granted me a liberty to file a writ petition, which I did. Well, that court said since it's a nil order, I cannot. Well, that cannot be the
Nil is also insufficient.
Yes, nil order is also insufficient. Well, they could have that is the simplicity thing. Well, that was challenged. Well, I had
that is the insufficiency.
That is well, but
that's if you my learned friend, that should be he should prefer an appeal.
No, my lord. Appeal I could not have had filed from the district judge's order. I could not have had filed an appeal here. Well, in Assam Courts Act, if it's a senior division's order, if it is acting as a civil court, then I can prefer an appeal under the division bench over.
No, it will not be appealable. It was in a case.
Well, then it would have had.
Then I am acting as the 6 and 16(3) court.
Yes. That is also
my lord, I understand.
Because I will not be entitled to go into the factual sufficiency or insufficiency.
My lord can grant a direct. My lord has the authority and jurisdiction to pass a writ of prohibition upon the 16D court to consider this, with the observation that this is also nil order is also insufficient order. Only that bit my lord can do. My lord, we can go and pursue it. Just that be spelled out, my lord, we will pursue it.
That could have been done earlier also.
Well, perhaps. My lord, that bit, if my lord
again it comes to me and I send you back to the same forum, it makes.
My lord, I understand, my lord, but my lord, I am rendered remediless. My lord, 16D, my lord, the understanding of the concerned district judge was absolutely wrong as far as 16D provision is concerned.
Insufficiency is insufficiency.
Insufficiency, my lord. There cannot be 0 to 1.
Whether it is 1 rupee or 0 rupee.
My lord, my lord.
1 crore, whatever.
My lord. 0 is also a quantum.
Yes, 0 is also a quantum. 1 crore is also a quantum.
My lord. Yes.
Maybe you are paid 1 crore and you say it is insufficient because you want 100 crore.
My lord.
So that is also insufficient.
My lord.
Insufficiency is not a well-defined term.
My lord. My lord got it. My lord, this is where I got stuck. And my lord, I had been hovering. And my lord, it was a land, a very lucrative land, right beside the national highway. My lord, high tension wire, and how, my lord, I am also ready to demonstrate how the high tension wire I cannot raise it to a limit. Well, at the 30,000 volt, if wire is hung on my land.
There is a division bench judgment of our court where it has been stated that the district judge is the authority to decide.
Yes.
You have it. Justice Chakraborty, our acting Chief Justice, decided over the division bench.
But just
that point was settled there. Because there was a tussle whether DM or DJ.
And also, my lord, Act also
Act is there, but the division bench will help me because I am now considering it as a writ court. So I can cite that authority and send him back there. That will help.
Just
have
now
that.
it is not with me.
Well, anyway, my lord can, my lord. Anyway, my lord.
I can, but
yes, my lord.
In view of the earlier revision court's order, I will have to decide it. If I don't decide it, I need the division bench.
I understand, my lord. I understand.
And I cannot decide it because it is a disputed question of fact. It can't be decided on the basis of affidavit evidence. How much will be sufficient?
Affidavits were exchanged, though.
It can't be decided.
Huh.
How much will be
The quantum,
loss
I
that was
understand,
suffered
Lord.
by you? It
Absolutely.
requires evidence.
Absolutely.
How will I
Absolutely.
say? You will say 5 trees were cut. He will say no trees were felled.
Absolutely, my lord.
How will I decide on
Absolutely,
absolute
my lord.
evidence? You will say yes. He will say
I understand, my lord.
it will be oath versus oath. I can't decide on summary.
My lord, I'm
evidence.
grateful that my lord has understand my predicament. I had been like from pillar to post. In the writ court, the respondent authority said that we are
You have
okay
that
for the
judgment,
compensation.
Mr. That
No, just now it is not, but it is
There
a
is-
true. It is a true that there is a division bench
yes,
judgment.
it has settled it. I don't remember it offhand, but I know for sure that it is there. Dr.
My lord,
Sahara, you have
my lord,
it?
may I just assist my lord? My lord, may I just assist my lord with a judgment in the present case? My lord, one Supreme Court, what it has held, if I may, my lord. My lord, Kolpaturu power transmission, one of the Supreme Court, my lord, this has remained great. Before my lord, it has been filed. My lord, at para 27. This is, my lord, the case law is, my lord, 2025 SCC online 1731. My lord, at page para 27, if my lord looks into.
Yes.
In the present case as well, some parties invoke Article 226 of the Constitution, where others have filed petition invoking 227 of the Constitution. This is solely because no proper appellate remedy has been provided. The only scope of interference in exercise of extraordinary judicial high court is within the parameters of the judicial review, which my lord has. If we examine the scope of the appeal under the statute, case in both open rehearing, both and question of facts and law. The first appellate court is required to address all the issues considered in the order of funeral recited and the same given reason. It is in fact continuation of the original proceeding. The power of the first appellate court is coextensive.
Mr. Haldar, I will not be able to set aside the district judge's order since it has not been interfered with by the revisional court here under 227.
I understand, my lord. I understand.
If it has not been done by that court, sitting in writ, I will not be able to set aside.
I understand, my lord.
Equally, I will not be able to interfere with the 10D order because that will be entering into disputed questions of fact.
So, my lord, the best
All
is
that
if my
I
lord
can
can
do,
relegate it
I
back,
can,
my lord.
yes, I can send you back to the authority.
With an observation that what my lord has held, my lord, that only that bit be considered, my lord. Only that be spelled out.
Yes, to reconsider.
To reconsider.
Based. If they,
he will have to file afresh because reconsidering afresh, this order will stand in the way.
Very well.
they file a fresh representation.
Earlier order will stand in the way. Earlier order as well as the revision court's order.
Yes, my lord. Yes, my lord.
Because I am not Supreme Court. I cannot set aside this order.
I understand, my lord. I
am bound by this also. I am bound by both.
I understand, my lord.
Let me think over it. I am just adjourning it for the day. Next week, same time, I'll upgrade it. I'll hear it out and pass orders.
I'll be grateful.
I'll
be grateful, my lord. Some remedy be rendered, my lord. My lord has that. I am so grateful that my lord has perceived the ordeal of my client, my lord.
In the meantime, I also try to that division bench judgment.
দেখে রাখো যে ডিভিশন বেঞ্চে কি জাজমেন্ট বলছে ঠিক আছে
লিখে নিই। Out of list.
Grateful, my lord.
A short matter, it is a challenging the ombudsman order already covered by the judge.
193 not today kore. Not today. Yes, next. Next. এটা দেবেন আবার ছেপে দেবেন না সমরদা not today 193 next কি 196 কোথায় বলছেন
That's why I appear for the petition.
other side not today next
207.
petitioner লিখে নিন none appears for the petitioner the respondent is represented
Sorry. 8 Lordship, I have instruction to withdraw this.
8 I am not.
thank you
দাদা এটা নিয়ে
দেখি ওটা দিন
Written instruction.
লিখুন Mr. Haldar, learned advocate, appearing for the petitioners, hands up to court, a letter dated
I appear on
209 out of list করুন নাম দিয়ে দিন
WBSD এর নামটা লিখেন ও আবার দিতে হবে নেই তো
Sleep নেই
210 লিখুন none appears for the petitioner 210 এ লিখুন
Half of the UCO
none
bank.
appears for the petitioner no accommodation is paid for
Item number 210, I am appearing on behalf of the UCO bank respondent.
none appears for the petitioner no accommodation is paid for UCO bank
of the Honorable Justice Rovi Kishan Kapoor. CSC authorities are held an inspection and thereafter they have issued the quotation and the connection has been given. Lordship.
it has become infructuous very well I'm
Lordship.
disposing this off লিখে নিন you are appearing for CSC both Please, 212 same order out of list. None appears for the parties. Let this matter go out of list. None appears for the parties, eh? Next.
Usman WBSC. Pardon, my lord, I beg to appear on behalf of the petitioner, madam. The petitioner is a private educational institution, madam. Now,
Mr. Shah is appearing on behalf of the WBRC.
Let them come, not today.
I am for WBSC.
Yes, but WBSC, ERC is not there.
Actual answering, though they have challenged the order passed by the ombudsman, but actual answering respondent is the WBSCDC. If your lordship thinks that his presence is required, subject to lordship kind approval, the matter gets.
Very well, please.
Because I don't want to keep this matter.
My lord, this is an education, private educational institution. According to tariff order, my lord, according to private educational institution, the demand charge will be D4.
Demand charge?
Demand charge. That is, my lord, kindly see, my lord, page 45.
Page 45.
45. Tariff order, my lord, is at page 42.
Starting from 40.
P3. Tariff schedule.
45.
Tariff schedule is at 42.
Starting from 42.
Starting from 42.
You are aggrieved by the order passed by the ombudsman.
My lord, my lord.
Where is the order? Please place
Order,
the order.
my lord,
first.
my lord. At page 113, my lord, P25, my lord. The complainant has a capacity, may I read, my lord? The complainant has a capacity of Secretary of the Shikha Sammalani Samiti has approached this forum regarding fixation of demand charge as private educational institution, low and medium voltage consumer, instead of commercial consumer. On asking a factual report, the licensee has submitted a report by memo Shasan Shas, which is considered as report of the opposite party. The case is accordingly taken up on 13/11/2025 in the presence of the following: my lord, appeal petitioner Indrani Chakraborty, Sri Subrata Saha, my lord, for licensee. At the outset, both the parties submitted their respective arguments. On the basis of the today's hearing, it is held that since at present the petitioner hearing at educational institution, my lord, ombudsman, my lord, has admitted that it is an educational, private educational institution having a demand and connected load of 88 kVA and does not belong to D4 category of tariff. So the petitioner is not entitled to get the tariff rate as claimed by him. However, the AP may get the benefit of D4 category of tariff provided the AP herein reduces the load capacity below 50 kVA as suggested by the opposite party. Since there is no other grievances of the petitioner, the case is to be finally disposed of without issuing any draft settlement order, which is also agreed to by the parties. Hence, in terms of clause 10.5 regulation of Shasan Shah's final order is issued that the appeal petitioner, my lord, herein the education institute may reduce the present load capacity below 50 kVA to get the benefit of D4 category of tariff. B, that the case is thus finally disposed of. In terms of clause 10.6 of regulation, my lord.
What is D4 category?
D4 category, my lord. I am here, my lord. Place for the no, please.
Yes,
Dr. Sahara, please.
Please, please.
Let me place my place before my lordship.
Sure.
Page 45, my lord.
Page 45.
Yes, my lord. According to tariff schedule, my lord, serial number 12, my lord.
Page 45.
My lord.
45, page 45. Yes. Serial 12.
Serial 12, my lord.
Serial number 12.
12. Private educational institutions and hospitals.
Yes.
Rate D4.
Consumer category.
Consumer category.
Yes.
My lord. Consumer category D4.
Demand charge.
And fixed charge / demand charge 100. Now, what has happened? The board, the company limited, my lord, is claiming that no, we are commercial consumers. Why? Page 46, kindly, my lord, page 46. This is the rate, my lord, for commercial consumers, those who would use 50 kVA and above. Serial 16, my lord.
Their demand charge is 270.
Page 46, here is demand charge is 270.
They are charging as per the consumer.
Consumer category, BIDC.
This is the main issue around the private educational institution.
But we are the private educational institution.
How can they charge 270 as per commercial?
So, my lord, how we can be treated as commercial consumer? Here, my lord, it is a rate given for commercial consumers, those who would use 50 kVA and above. We are private educational institution according to tariff schedule. And Ombudsman also has admitted that we are private educational institution. It is admitted. So why not, my lord, we will get the rate before, that is demand charge 100. This is the sum and substance of the case.
Yes, Dr. Sahara.
But this is a peculiar case which has been placed before your lordship. But this is the second round of litigations. So far, the first round of litigation is concerned, the matter has been relegated to GRO. Your lordship will find that I have filed my affidavit in opposition, from where it will be crystal clear why this fixed charge has been taken into considerations. Now, if your lordship kindly take my affidavit in opposition for a moment. Lordship, kindly come to Annexure R1. This is the tariff order. Your lordship is well aware that this tariff order is the fixed rate which has been fixed. And on that basis, if your lordship kindly turn to next page, page 8, kindly see the heading. Low and medium voltage consumer. Admitted position, I can show from that pleading that they have got 88 kVA. 88 kVA means above 50 kVA. That tantamounts to bulk consumer. And when he amounts to bulk consumer, if your lordship kindly see the next page, page 9, the commercial consumer, which is 50 kVA and above. And when it is it's a institution, it's not that the private
But
is.
they are also under the same heading, low and medium voltage consumers.
No, it's they are not under the same heading.
Page 9 top C. Page 9 top. Low and medium voltage consumers. Same thing is
kindly see low and medium voltage, and what is specified commercial consumer.
Yes. So that
50
is why,
kVA and above.
That is why Dr. Sahara, so that you can answer, low and medium voltage consumers contain several categories. One of them is educational, private educational institutions. Another is commercial consumers.
Lordship.
Now, in commercial consumer category, you may have commercial consumers who are consuming less than 80 kVA. You may have commercial consumers who are consuming more than 80 kVA. So far as commercial consumers who are consuming more than 80 kVA is concerned, or 50 kVA is concerned, this will apply. But if you have a separate private educational institution bracket, how can you bring them in the bracket of commercial establishment?
Lordship, kindly see the observation made by the GRO as well as by the Ombudsman, where it has been specified that when it has been specified that initially they have got less than 50 kVA.
And Dr. Sahara, the order of the Ombudsman does not give any reason. It comes to the conclusion. If you see, all the 4 paragraphs only state conclusions. Where is the reason? The reason why they are treating him, I mean the petitioner, as as not an educational institution who is entitled to the benefit of
in page 114, subject to your lordship kind approval, in page 114, in paragraph 5, Ombudsman
paragraph
said
5 is the reason. Kindly see, on the basis of today's hearing,
it is held that since at present
so it is held is a conclusion. Thereafter also he says he may get the benefit if he reduces. But when he comes to the conclusion that he is an educational institution having demand of such and such load, therefore he will not belong to D4 category, where is the reason that despite being an educational institution, he can be brought into the bracket of commercial consumers? Where is that reason? How does he establish the
Ma'am,
nexus
then
between the-
may I place my GRO order? If your lordship kindly see
Please.
the GRO order which has been passed. Kindly come to page 92.
Page
92. If your lordship desire, then the matter can be relegated to only on that point. The reason has to be assigned.
He has to
Subject
assign
to your
his-
lordship.
He cannot.
Yes, subject to lordship. That can also be done.
2 years
Because
back.
the law is well settled, your lordship. Whenever it has been specified.
Now is running without electricity.
Charge, if your lordship see the below rate, fixed charge will be applicable for the consumer. If your lordship kindly come to page 9 of my affidavit in opposition. Page 9 of my affidavit in opposition.
Sorry to say, my lord, college is running, my lord, without electricity
Fixed charge.
for about 2 years.
That means they are not a private, it's a commercial institution. Fixed charge.
No, Dr. Sahara, I would have understood commercial institution if you did not have
that
the
reason
separate-
has to be assigned.
and you did not have a separate category of private educational institution.
No, lordship,
When you
yes.
say private educational institution and you do not categorize private educational institution with a particular KVA consumption, then why do you say that he is a commercial consumer?
I tell
He
you,
is
lordship.
still a private educational.
I understand what has fallen from your lordship. May I summarize it? But so far the low voltage and medium voltage is concerned, your lordship is well aware it is less than 50 kVA.
No.
Less than 50 kVA.
It doesn't say so. Page 9, low and medium voltage consumer also comprises commercial consumers 50 kVA and above.
Kindly see the bottom, in the bottom it has been written note. Kindly see the note. Fixed charge. Kindly take note on that. Fixed charge will be applicable for the consumer having contract demand below 50 kVA, and demand charge will be applicable for the consumer demand of 50 kVA and above. So when it is above 50 kVA, this fixed charge of 270 is coming into force. So it is immaterial when it is below 50 kVA or above 50 kVA. It is admitted fact that when it is coming under the purview of above 50 kVA, the fixed charge will come into play. It is a specific note, it has been specified, lordship.
Yes, he is right in that. If you see the note, fixed charge will be applicable for the consumer having contract demand below 50 kVA. So you are not having your contract demand below 50 kVA. Therefore, fixed charge will not be applicable to you. To you, demand charge will be applicable.
Demand charge and demand charge also.
Slash demand charge.
Slash demand charge.
Where slash?
Demand charge.
Where?
My lord, page 8, my lord.
Serial 12.
Serial 12, my lord. Fixed charge slash demand charge.
In rupees.
In rupees per kVA.
6th column.
6th column, my lord.
It is above 50 kVA. So
No.
has to be compliant.
Demand charge will be applicable.
Yes. Fixed charge slash demand charge means
Demand
whatever
charge
is
will be applicable.
The applicable head will have to be applied. Fixed charge will be applicable to you if you are below 50 kVA. It is slash. Therefore, either of the two. Which one of the two will be connected with the demand contract demand? If your contract demand is above 50 kVA, then in that case, demand charge will apply. If the contract demand is below 50 kVA, then fixed charge will apply. That is how the note has to be read.
My lord, demand charge will be applicable for the consumer having contract demand of 50 kVA and above.
Yes. So you have a contract demand of 50 kVA and above. Therefore, to you, demand charge will apply.
Yes. Here it is demand charge. Fixed charge
slash demand charge means or. As the case may be, it has to be read as the case may be.
100.
It can't be universal. It can't be universal. Fixed charge will be applicable if you can show that your consumption below or contract demand is below 50 kVA. Fixed charge will be applicable. If your contract demand is above 50 kVA, then in that case, demand charge will be applicable. It can't be the other way around.
My lord, demand charge is written as 100, my lord.
In your case, demand charge will not apply. Your case, demand charge will apply only if, demand charge cannot be 100. It is fixed charge which is 100.
Where, my lord, it is written that demand charge will be
And
applicable.
yes, Dr. Sahara, he is right in that also. If the the charge itself has been quantified at 100, whether it is fixed or demand, then in that case, in private educational institutions, it has to be 100.
So far it is below 50 kVA, then it is applicable. And if it is above 50 kVA, then the 270 is a fixed charge.
Private
That is
educational
because
institution.
note is very much crystal clear.
No,
Kindly
no.
see.
Note is clear, but the note also has to be applied in terms of the chart.
Ma,
The
let the
chart
ombudsman decide on this issue.
Yes.
Let the ombudsman.
No, my lord.
order on
Ombudsman already rejected my
I
case.
cannot decide it. This is something which is technical.
Yes.
I will not be able to decide it. It has to go before the ombudsman.
My lord, let them connect the electricity, my lord.
That you have to pay whatever dues are there.
There is
My lord,
almost 3 lakh rupees
Mr.
due.
Saha, I am
my lord, my lord, kindly, my lord, kindly, my lord, fix a sum
yes,
which I can
I'll
pay,
fix a time frame.
and to
The ombudsman's order is unreasoned.
and to reconnect the electricity.
I get 1 day time. Today
To
I am
connect the
pending a
electricity, to reconnect,
I have missed the list.
reconnect the electricity.
Brief is not there. Tomorrow at any point, anytime. Anytime. Well, I will come back.
Ma, I think
There are
ombudsman
customers
will clarify the situation because it is the fixed tariff.
No, but clarification from the bar will not do. He cannot supply reasons to
Ma,
the order.
then
which
the
is
ombudsman. Now this has fallen rightly before by your lordship.
See the order. You see the order of the ombudsman. You will not be able
But I
to
have
defend.
instructions. Let me, my lord.
Right, but whatever instructions you have, it will not. You cannot be. You
No,
will
I
not
cannot
be able
improve
to
that. That is
insert
not-
it into the. See the reason. He starts with it is held. So he has held on the basis of what? That is a conclusion. Where is the reason?
88 kVA.
On the basis of today's hearing, it is held.
Ma, let it be clarified by the ombudsman.
What is the basis of this held?
Let it be sent back, my lord. Let the
Let it
ombudsman
be
clarify.
clarified by the detail
In
on
the
that
meantime,
point.
my lord, connection
No,
be
they are
given, my lord,
termination.
on condition that we shall pay a sum, my lord.
That I will give you liberty if you can approach them. They.
My lord, they will not give.
No, I will not direct
My
mandate.
lord, for 2 years, my lord, the college is
Yes,
without
that is why
electricity, my lord.
I cannot say that you pay even if there is pending.
My lord,
If you want, I can give you liberty
we,
that you will approach them.
we will pay the energy charge, my lord, in the meantime.
I can grant you liberty. There can be no mandate to that effect. I will not pass a mandate.
Without electricity, my lord, for 2 years.
Oh, I cannot do charity here. It is not my money. It is.
Well,
state's
here
money.
is the illegality, my lord, perpetrated by the, my lord, board, my lord. So, my lord, the court should interfere, my lord.
This writ petition assails an order dated